we have invited Professor Saroj Sharma, who is chairperson of National Institute of Open Schooling, to be there with us in the valedictory as a chief guest for the event. And me and Professor Raman Mittal will also be there to take final feedback from you and to thank you and to congratulate you for on successful completion of the program. Um, so not only related to pedagogy, but related to this course or such courses which will be coming up with in the near future. You're most welcome to come out with your challenges you have faced, technology related, content related, selection of speakers related, whatever you feel like, kindly feel free to write us. You can write us on our emails. My email is there on the website of IEEE. It's director@iill.du.ac.in. Or you can phone us. I am part of your WhatsApp group. We can chat there also. And not taking much time, now I would surely would like to hear something from the participants. I can see around 18, 17, 18 people are there at this moment. So anything you want to share, anything you want to highlight, you want to bring it to our notice, please feel free to share. Last point, I must inform, though Dr. Jayaprakash and Dr. Yukti would also be letting you know, we are almost ready with your certificates. You can see on your screen. These certificates are almost ready and signed by a campus law center professor in charge, Professor Raman Mittal. And after tomorrow, we'll fill in names also for the people who have attended it for the 100%. Because 5 days course, we cannot give a choice to attend it 80% or 70%. So certificate will be given to those participants who have attended it for the 100%. So after tomorrow, you can collect it from IEEE in person. And if you want its soft copy, we can scan it and send it to you through our office. Mr. Ravi would be coordinating this from IEEE side. And now, Jayaprakash ji, please invite one or two people if they want to share something, if they want to ask something. I couldn't see anybody's hand raised for saying something. Dr. Yukti, please take it forward. And I'm here with you for some time, though around 3 weeks I have another meeting. But in next 10 minutes, if we can hear one or two participants.
Yes, sure. Thank you, Professor Pankaj. Uh, we have another 10 minutes before we begin the session. So, any feedback I know this is a very cozy group of 17 people who have been attending from the first day. But I can also see from the last 3 days that all the participants were very closely engaged with the topics that were being shared during the sessions. So this close engagement definitely, creates this need in us that we want you to give us some feedback related to the organization of the program also, and relation to the content also, because as I was saying, it's going to be a recurring program, and gradually we are going to diversify from DU faculty members and research scholars. We may open it to other universities also, and therefore your feedback is all the more required for updating this program.
Ma'am,
So
can
any
I
of
ask?
you would
Can
like
I?
to say?
Yeah,
Yes, Dr. Naveen.
ma'am.
I saw that you have been very, very participative and actively involved from the last 3 days. So, if you would like to
Yeah,
share,
ma'am.
please.
Yeah, that is why I joined the course, no? So to get
Can't
some
hear you
knowledge about this.
some. Yeah, yeah, yeah. Now
Ma'am,
I can hear you.
is my voice coming? Ma'am,
Yes, yes.
since we have faculty members from law center, so we have some database of private companies. Like I have purchased it myself from Taxman, so it's very costly. Does DU has this facility that DU provides this database of these taxmen or what ITR, etc., income tax reporter? There are some private companies. who are having the text database where they have acts updated, rules updated, notifications, circulars, court cases. तो क्या डीयू ने ऐसा कुछ सब्सक्राइब किया हुआ है क्या वेयर वी कैन गेट दैट सब्सक्रिप्शन फ्री ऑफ कॉस्ट? एक तो ये मेरा पॉइंट है, ऐसा कुछ है क्या दिल्ली यूनिवर्सिटी में? सर आई थिंक यू आर म्यूटेड सर. सर यू आर ऑन म्यूट.
You are a person of commerce, and we expect you to provide such information on GST through Commerce Department, because Commerce Department is a department of university which is very resourceful with lot of professors now. Almost everybody is professor now. This is what I am told.
Everyone, not almost sir, 100%, 100% professors in Department of Commerce. No assistant professor, no associate now.
So such a rich department. I am sorry, because we cannot provide resources for specific disciplines. For specific disciplines, you have to approach to concerned department. They would be
नहीं नहीं
able to provide.
नहीं नहीं सर, कोई रिसोर्सेज की बात नहीं कर रहा हूँ मैं, सिर्फ सब्सक्रिप्शन की बात कर रहा हूँ जो डेटाबेस है. आई एम नॉट आस्किंग फॉर एनी रिसोर्स पर्सन. क्या दिल्ली यूनिवर्सिटी लाइब्रेरी में ऐसा कोई सब्सक्रिप्शन है क्या एज फार एज दिस टैक्समैन इज द डेटाबेस और इनकम टैक्स रिपोर्टर एक डेटाबेस है? दिस कंपनीज, दीज आर प्राइवेट कंपनीज. तो हो सकता है कि दिल्ली यूनिवर्सिटी ने शायद इनको सब्सक्राइब किया हुआ है क्या? मुझे सिर्फ ये पूछना है.
No,
ऐसे आपकी नॉलेज में कुछ ऐसा है?
not to my knowledge, but if any participant have any knowledge, I think
या
Ruchika is there. She is very active in university administration
या
also.
जयप्रकाश सर भी लॉ फैकल्टी से, शायद इनको आइडिया हो.
हाँ सर, वही मैं कहने लगी थी, जयप्रकाश सर बता सकते हैं, शायद ही कैन हैव एन आइडिया.
Okay, thank you for the your kind words. Uh, I will request to the Professor Arora that we can have the e-resource session on some day with the librarian. So he is the best person to guide us in this regarding, and he will have the answer for all this of the question that which database with the Delhi University subscribed. So the Dr. Rajesh Singh is the librarian, and if the you may also personally approach the Professor, sorry, Dr. Rajesh Singh librarian in the Delhi University Library, so we can get to know that what kind of these resources are available, which is subscribed by the University of Delhi. Thank you.
सर आज भी एक सेशन है शायद दिल्ली यूनिवर्सिटी लाइब्रेरी का जिसमें एसएससी कोई प्राइवेट कंपनी है, तो आज कोई सेशन है उनका 3 to 3:30, 3 to 4:30 आई थिंक, जिसमें कोई डेटाबेस है शायद, उसके बारे में बात करेंगे. मुझे सिर्फ ये आइडिया नहीं है कि वेदर वो एक कंपनी सिर्फ अपना एक डेमो दे रही है या डी यू ऑलरेडी हैज सब्सक्राइब टू दैट डेटाबेस. आज एक सेशन है उनका, अगर आप देखें लाइब्रेरी.
Sorry, I am not aware about that. But yes, if they are showing that, giving the demo, then definitely they with Delhi University subscribe that. This is the usual practice.
ओके.
Yes. Any other feedback anyone want to give?
Sir, I have a suggestion not regarding this particular workshop, but we can plan on the pedagogies which we can use in our classrooms, be it at college or university level or at school level. This is a general topic that is very much essential for a teacher to know and have knowledge about these new pedagogies. So we can have a session on that, like inquiry pedagogy or critical pedagogy. Yes.
Sir, can I speak now?
Surely this suggestion would be considered, and the upcoming course on pedagogy will write in copy. Thank you for suggestion. Yes, Ruchika.
Sir, so I would like to thank all of you for organizing this course. Before joining this, I was very apprehensive because law थोड़ा technical, वो quiz के बाद तो समझ आ गया बहुत ही technical होता है, थोड़ा नहीं. And the kind, still the way so many concepts are given in such a short span of time by every speaker is really appreciable, sir. Thank you so much. This is a great idea, and I think you should float it on all India level. So having small batches, but it's a great idea. So because at these misconception was there that जो victim है सिर्फ वही FIR लॉन्च करेगा, तो वही छोटी छोटी चीज आज मैंने ग्रुप में हंसते हुए भी लिखा था कि क्विज के बाद समझ आया कि लॉ इज वेरी टेक्निकल. सो दीज आर सर्टेन एरियाज जो हमें सबको ना लगता है कि पता है लेकिन पता नहीं है. And to gain the exact knowledge, these short-term courses are very useful. So really thankful to you and Raman sir and the organizing team, because I know everyone is doing their a bit. थोड़े से लोग आगे होते हैं, थोड़े से लोग बैक एंड पे काम कर रहे होते हैं. So thank you so much.
Thank you.
बस एक अटेंडेंस का मेरा एप्रीहेंशन है. अपने 100% अटेंडेंस बोला है, तो सर मेरा ही नेटवर्क इशू 2 दिन से बहुत चल रहा है बिकॉज ऑफ क्लाउड्स. सो अब पता नहीं कितनी अटेंडेंस हमने फिलअप किया नहीं, दो आई एम अटेंडिंग ऑल द सेशंस. सो हाउ डू वी क्रॉस चेक दैट?
That Jayaprakash ji and Professor Yukti will tell you. They have all the attendance track with them.
So all of us are getting the certificate.
Thank you for this feedback about the significance of this program. In 2020, in the advisory committee meeting itself, we realized the importance to have some legal literacy for the people who are not from law department and have not having any degree in law. So we just shared our idea with Professor Ahuja first and then Professor Raman Mittal. And as in the inaugural session I mentioned, we were really delighted. The moment I shared, they said, surely we can have such program for the community at a later stage and university faculty and research scholars for the first phase. We are planning to expand it to the community at a later stage. So this time we just most of the courses what we are running now are as a pilot, and those videos are available on our IEEE website. And gradually, we want these video lessons to be used by resource people without inviting experts again and again. And somebody like Jayaprakash ji can be anchor, and after each video screening can have a discussion for clarifications, for questions, for open session. And I am sure that will be helpful to more people. In the first round, we have Google. Gradually, we can move to a larger platform where we can accommodate more than 100 people. Thank you for this feedback. Uh, I will take your leave now because, as I mentioned, I have another meeting on DU Discat, where university is trying to provide digital infrastructure to all the colleges and all the departments. So for that, we have a meeting scheduled at 3 p.m. today, which is blended mode, offline and online. Two colleagues have already arrived in my office to attend it offline, and there must be few colleagues who would be attending it online. So I need to join online also. Each also. Jayaprakash ji is there, Professor Yukta is there. Again, only for the present. Thank you very much. Namaskar.
Thank, thank you, sir, for uh, your valuable suggestions. Thank you, sir.
Sure.
Okay. Uh, Before we start the our first session, there is a attendance of this opening session also. So the link is already shared in your chat box, and I will give you the time. So the first session will start at 3:05 sharp.
Dr.
Please
Jayaprakash,
be there.
yeah,
Yes.
Dr. Jayaprakash, I wanted to say the same thing what Dr. Ruchika was asking right now. So, and Neeraj was also asking. So, Dr. Jayaprakash has already mentioned this before also, that if suppose you are not able to fill the Google form for attendance because of some network issues, but you are present in the session, then we would address that issue after the course is over. So we are going to see, look at your attendance, and we will see where are the gaps where the attendance is not there for which session, and you would be given an opportunity to give a screenshot or something for the session, because the recordings are already with us, so that also is a proof that you were present. So please don't worry about it. That way, IEEE is always very supportive, because we don't want people to
just because of attendance. And some of you, like Dr. Ruchika, is very actively participating from the first day. So we already know that she was present in all the sessions. Many of you, Dr. Naveen, I've seen, Dr. Amrit, I mean, they all are present since the first day. I've been seeing, I also attended all the sessions on the last 3 days. So I've seen your participation also. And this is a small group, so it doesn't matter much. But you know, when many programs have to be organized, then you know what happens is this particular mechanism becomes important just in order to maintain the continuity of learning, which we want to be promoted amongst the learners. You know, we all become learners when we join a course. So for that, it is important that we have this mechanism. And unfortunately, it is unfortunate for me because we had to give a Google form for the open session also, because yesterday the attendance was observed to be very low during the open session. So that's why today for open session also we have introduced a Google form, and also for the other two sessions you will be given session wise one Google form. So please take care that you are able to fill your attendance in the Google form. So I hope you understand the process and the need of this whole process, to which we also don't agree to a large extent. So thank you very much once again. And now I'm going to request Dr. Jayaprakash to take this forward and invite our speaker for the day. Thank you all.
Thanks,
Have a
ma'am.
good day.
Thanks,
Thank you,
ma'am. We
Professor
fully
Revati.
understand. We fully understand.
Okay, thank
Okay,
you.
thank you. Thank you,
Thank
Dr.
you, Professor
Ruchika.
Revati, for this. And so right now I am giving this till the 1 minute is left, so you can fill your attendance sheet. After that, our first resource person of the day will start their lecture. So please fill the attendance sheet. We will start at 3:05 sharp. So now this time to start the today's session with our first speaker of the day, and that is the Professor Binjan Gupta. Professor Binjan Gupta will enlighten us on the negotiable instruments, and I'm sure that this session will be more interesting, as it is useful in our day-to-day life also when if you connect it. So before I formally request, I let me introduce the Professor Gupta. Professor Dr. Binjan Gupta is a professor of law at the Campus Law Center, Faculty of Law, University of Delhi, with the experience of more than 25 years of the teaching, from where she completed her academic degree. Her doctoral research is on the law relating to the dishonor of the check. Professor Gupta was the editor of the Journal of the Campus Law Center in 2013. She has been appointed as the grievance officer in the University of Delhi as per the provision of the privacy policy of the University of Delhi very recently. Professor Gupta has delivered several lectures as a visiting faculty on law of evidence, law of contract, law of negotiable instrument, etc. at various places, including the Innovative Institute of Law, Greater Noida. Professor Gupta is having to her credit various articles and write-ups in the journals of the national repute, and has participated in many national and international seminars and conferences. She has authored and credited several books published by publisher of the international repute, including LexisNexis, more particularly on the dishonor of the checks, and commentary on protection of women from the Domestic Violence Act. She was nominated as a member expert in law by Ministry of Human Resource Development for shortlisting of application for 2016 Commonwealth application in UK. She has also been called as a VC nominee for appointment and promotion in the King's College and the Department of the University of Delhi. Without taking much more time, now I am inviting the Professor Binjan Gupta. I also want to request from the participant that if you have any query, you may ask in the when the floor is open for the session, so that whatever your query in the end you can ask without any kind of the disruption. So over to you, ma'am.
Thank you, Professor Jayaprakash, and thank you, Professor Yukti, and for introducing me and welcoming to this program. And I, in fact, have been allotted the topic that is in Negotiable Instruments Act 1881. The topic seems to be quite wide, so I have selected an area on this negotiable instruments, particularly with regard to law relating to dishonor of checks, which happens to be my specialization for my PhD thesis. So I would, since teaching of law is not that easy task, we require the primary source for that, and that is the act, which I suppose many of you may not be having with you for reference sake, and also the other direct sources is decided cases. And since all of you happen to be a non-legal background, so going more into depth with the cases would not be taking place here. I would not be in depth taking up the cases because I have a schedule of 1.5 hours time to complete the topic, which I suppose would try my best to cover it. So I have certain slides here to show you so that you people can refer to it and understand with regard to law relating to dishonor of checks. So just give me a minute to connect it. Are you able to see?
Yes, it's
Yes, ma'am.
visible,
Yeah.
but it's the last
Okay.
slide.
Okay. Let me start from the beginning. So are you all able to see the slide?
Yes, ma'am.
Okay. So, as I just mentioned, that the Negotiable Instruments Act 1881 comprises of 148 sections, and to deal all 148 sections in such a short span of time is would be very difficult. So, I have chosen this area, that is law relating to dishonor of checks, under Section 138 as provided under Chapter 17 of the Negotiable Instruments Act. See, this act, if we focus on this act, giving you a brief introduction of the act, and then straight away I would be shifting to the law relating to dishonor of checks. See, the title of the act is Negotiable Instruments Act 1881, comprises of two terms, that is negotiable and instruments. So to understand in a proper way, we need to know the meaning of the word negotiable. Negotiable, as in used in common parlance, is going through bargaining, but here we have a specific legal meaning. Negotiable means transferable from one person to another in return for consideration. So negotiable actually is indicating transfer of the negotiable instruments. As such, the Negotiable Instruments Act defines the term negotiation under Section 13. Then we have the term used here in the act, title of the act, that is instrument. Instrument also has been legally defined. Instrument implies a written document by which the right is created in favor of some person. So these negotiable instruments, they are not simple instruments, simple document. They are the documents which in fact create rights. They are embodiment of rights. And when they are transferred, the rights along with that also gets transferred. This Negotiable Instruments Act, which is dealing with the negotiable instruments, actually is akin to a contract. So the question arises, it should have been dealt with under, it should have been covered under the law of contract, that is Indian Contract Act 1872. But we have with us a special act which deals with these negotiable instruments. And these negotiable instruments as such has been defined under the Negotiable Instruments Act under Section 13 of the Negotiable Instruments Act. Now, Section 13 in fact states that the Negotiable Instrument Act means a promissory note, a bill of exchange, or a check. The Act also defines these terms. Promissory note promissory note is defined under Section 4. Bill of exchange is defined under Section 5. I don't know how many of you would be familiar with these terms. Just to go in brief, because in depth I would be focusing on checks, as I would be dealing with law relating to checks, dishonor of checks. So just quickly going through the term promissory note or promissory. So in fact, before I take up the definition, Negotiable Instruments Act only deals with three kinds of instruments as mentioned under Section 13, that is promissory note, bill of exchange, and checks. Now, what is a promissory note has been defined under Section 4. It states that a promissory note has to be an instrument in writing. So a promissory note cannot be in an oral way, it has to be in a writing, not being a bank note or a currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instruments. So this definition seems to involve certain terms, and it also mentions certain requirements to call an instrument as a valid promissory note. So let me split up this quickly. That is, in order to call an instrument as a valid promissory note, first requirement is it has to be in writing. Second, it has to be an unconditional undertaking. Unconditional means there should not be any conditions attached to it. And undertaking here states that it should be in the form of a promise. But it is not mandatory the term promise or undertaking should have been mentioned in the instrument. The next requirement is to fall into a category of a valid promissory note, it requires the signatures of the maker. The maker of the promissory note has to sign it. Without the signatures, it would not constitute as a valid promissory note. And a pronote, in short, we call this promissory note as a pronote. This pronote has to involve only, it is with regard to payment of money. If along with money, something else is included, mentioned in that pronote, it will fail to be called as a promissory note. And money has to be very specific. If some uncertainty happens to appear on the instrument, then also it will lose its validity. And last, that is, it has to be payable either to order of a certain person or to the bearer of the instruments. The term order means as per the direction of the person who is named on the instrument, who is called as the payee of the promissory note, or the bearer of the instrument. The term bearer means whosoever is in possession. But when we talk about the term bearer, as per Indian law, it is not simply the person who actually is in possession. The possession as such, for a person to be called as a bearer has to be a lawful possession. Simple possession is not sufficient. The person should be lawfully in possession of that instrument. So this is a promissory note. It is an unconditional undertaking. Coming to bill of exchange, which has been defined under Section 5, a bills of exchange is an instrument in writing, so it cannot be in oral. Secondly, it has to be an unconditional order. See, it's not an undertaking, it's an order, unconditional order. Order here refers to a direction to somebody. It has to be signed by the maker, and since it is an unconditional order, it has to have a direction to a certain person. The person should also be certain. If the person cannot be a certain, then also it will hamper the validity of an instrument to be called as a valid bill of exchange. And also a requirement to pay a certain sum of money. The certainty of sum should be there, and only it should involve money and money only, not anything along with money, or to the order of certain person or to the bearer of the instrument. Then coming to the third category of negotiable instrument, which this Negotiable Instruments Act deal with, is the checks, which in fact is very much in common parlance today, but slowly we find in the changing times it is losing its importance. Why? Because check is now substituted with the other ways of making electronic payments. So check has been defined under section 6, which I'll be taking as under the topic laws relating to dishonor of checks. I'll be taking up the definition over there. But before I proceed further, I would like to tell you these three instruments, pronote, bill of exchange, and check. What is briefly the difference between the two? In case of a promissory note, as I just mentioned, it is an unconditional undertaking, or you can say an unconditional promise involving only two parties. That is the party who actually is making the instrument, the maker, and to whose favor that instrument actually is executed is called the payee. Whereas in case of bills of exchange, there is an involvement of three persons. There are three parties, but sometimes there, in exceptional cases, there may be two. But generally, the requirement is there are three persons, three parties involved in a bill of exchange. One, the maker of bill of exchange, who is called as the drawer of bill of exchange, and the person who actually is directed to make the payment is called the drawee, acceptor, and the third party is the payee, actually in whose favor that instrument is executed. Coming to the check, see, check is actually nothing but a species of bill of exchange. It also has it has a mandatory requirement of three parties. That is, the maker of the check is called the drawer of the check. The person who is directed to payment is called the drawee. And the difference between bill of exchange and check is that in case of a check, the drawee is always a banker. Whereas in case of bill of exchange, the drawee can either be a banker or it can be a person. And the third party in case of a check is the payee, that is, in whose favor that check is executed. I initially mentioned that this negotiable instruments, they are basically nothing but is similar to a contract. So they should have been covered under the law of contract, that is Indian Contract Act 1872. But we have a special act dealing with the negotiable instruments. But the question arises, why do we have this separate act? Why? Because of certain benefits which are attached to these negotiable instruments. And the benefits which are attached to these instruments, they are fourfold. I've quickly just we go through what are the benefits of having these a separate act for dealing with this negotiable instruments. The first is that there are certain presumptions they get attached with this negotiable instruments, and these presumptions, they are provided in the act itself under section 118. I have detailed in the slide from A to G. These are the presumptions which are attached to a negotiable instrument whenever they are executed. But the question arises, what actually do we mean by this presumption, and what difference does it make by providing this benefit to these, attaching these benefit to the negotiable instruments? Presumption actually means drawing an inference. Drawing an inference on the basis of certain established facts. So if we talk about a check, if a person is in possession of a check, it would be presumed that the person came in possession of a check after passing on with consideration. The presumption, there is also presumption as to date provided under 118 clause B. There is also presumption as to the time of acceptance, as to the time of transfer, as to the order of endorsements, as to the stamps, whereas the checks doesn't require stamping at all, and also that every holder is a holder in due course. So I just mentioned, what do we mean by presumptions? Presumptions means an inference which is drawn on the basis of certain facts. See, in order to prove something before the court of law, the party who initiates the proceedings as per section 101 of the Evidence Act, Indian Evidence Act 1872, the burden of proof lies on the person who actually who alleges and who wants to prove certain facts. But when certain presumption is attached to something, certain presumption, as in the case of negotiable instruments, is provided, this burden of proof gets shifted onto the other party. So this actually is the benefit which we can say is attached to the negotiable instruments with the help of this Negotiable Instruments Act. The second benefit advantage we can say that it also provides for special rules of compensation under 117. I've detailed the rules of presumption which are provided under section 117 from A to E. I don't know whether you are familiar with the general requirement. Yesterday only, I suppose you had discussed about the law of contract. What are the basic requirements for a contract is that there has to be a valid consideration. As we just mentioned, the consideration has to be proved by the person who actually has knocked the doors of the court. And if he fails to establish that, he loses the case. But in case if he is in a possession of any of the negotiable instrument, as the case may be, if he is having in possession a check which is dishonored, he the burden is actually not on him. The burden, as per the doctrine of reverse burden of proof, is shifted onto the other party. That is, upon the accused drawer in case of a complaint filed under Section 138 of the NI Act. So this second advantage, that is special rules of compensation which are provided, that the holder is entitled to the amount due upon the instrument together with the expenses which he has properly incurred in presenting, noting, and protesting. Let me tell you this aspect of noting and protesting. Noting as such has been defined under section 99, and protest has been defined under section 100 of Negotiable Instruments Act, and it is only with regard to the pronotes and bill of exchange. It is not applicable to the checks. Then the second rule of compensation is that when the person charged resides at a place different from that which the instrument was payable, the holder is entitled to receive such sum at the current rate of exchange between the two places. And thirdly, an endorser who is being liable has paid the amount due on the same is entitled to the amount so paid with interest at 18% per annum from the date of payment until tender or realization thereof, together with all expenses caused by the dishonor and payment. Fourthly, when the person charged with such endorser resides at different places, the endorser is entitled to receive such sum at the current rate of exchange between the two places. And lastly, the party who is entitled to compensation may draw a bill upon the party who is liable to compensate him, payable at sight or on demand, for the amount due to him, together with all expenses properly incurred by him, and such bill must be accompanied by the instrument dishonored and the protest thereof, if any. If such bill is dishonored, the party who is dishonoring the same is liable to make the compensation thereof in the same manner as in the case of the original bill. So similar rules would apply thereof. So this was the second advantage which was attached to the negotiable instruments and which are covered under the NI Act. The third advantage, the third benefit for having this act is that whenever a case is to be filed with regard to negotiable instruments, the summary procedure as provided under Order 37 of CPC 1908 would be applicable, which otherwise is not applicable. So if the instrument happens to be a valid negotiable instrument, then this Order 37, a civil remedy can be claimed. And fourth, and the last benefit I would like to mention is penalties in case of dishonor of checks provided under Chapter 17. Now, let me tell you, this Negotiable Instruments Act is not a civil law, is not a criminal law, it's a civil law. But Chapter 17 was specifically inserted in this NI Act in the year 1988 with the basic objective to inculcate confidence in this system of payment of checks and in this banking system. And that is why, as it was seen, there was frequent use of the check and thereby dishonor of check also was so frequent that it required to tackle this menace in a proper way. So therefore, this chapter 17 was inserted in the statute, that is, or an NI Act, titled as penalties in case of dishonor of checks, uh, in case of insufficiency of funds into the account. So this penalties in case of, or so this is applicable only to the checks. And since bouncing of checks is an offense considered to be offense, so civil law, NI Act is a civil law, but it provides for a penalty only for bouncing of checks. It is considered to be an offense under section 138. And because it provides for a penalty, and the penalty which is provided is punishment with an imprisonment for a term which may extend to 2 years, or with a fine which may extend to twice the amount of the check, or with both. So these are the four benefits which are attached with these negotiable instruments, and that justifies that it required a separate act to deal with these negotiable instruments. Now, we focus upon the law relating to dishonor of checks. In order to understand first the law of dishonor of checks, we need to know what is a check. As I mentioned earlier, Section 13 defines the negotiable instrument includes a pronote, a bill of exchange, and a check. And check has been defined as such under Section 6. The definition as such, I would like to mention here. Check as such has been defined as a bill of exchange. I told you initially it is a species of a bill of exchange which is drawn on a specified banker and expressed to be payable otherwise than on demand. It also includes the electronic image of a truncated check and a check in the electronic form. Let me tell you the difference between a check and a bill of exchange here is that a check is always payable on demand, and in case of a check, the drawee is always a banker. Whereas in case of a bill of exchange, it can either be a banker or it can be anyone else. Now, since with an amendment being brought about in this chapter 17 in the year 2002, this definition of check was changed, and it was amended, and it added to it that a check includes, so this part that it includes an electronic image of a truncated check and a check in an electronic form was inserted to the definition of Section 6. And what is a check in an electronic form? A check in an electronic form means a check which contains the exact mirror image of a paper check and is generated, written, and signed in a secure system, ensuring the minimum safety standards with use of digital signatures with or without biometric signatures and asymmetric crypto system. Let me tell you, I did my research in this law relating to dishonor of checks, and it was in the year 2007 when I had submitted. I was enrolled in the year 2004, and at that time when I conducted the research, that was an empirical research, and during the course I did not even find a single case which was there in the courts with regard to a check in an electronic form. So still date also, to my knowledge, there is no such check which is in existence in electronic form. There is only a system which prevalent is electronic clearing, and slowly we now have other means of making electronic payments, and that actually is covered or tackled through a separate law that is called as Payments and Settlement Systems Act 2007. So that's separate. Then what is a truncated check? Truncated check actually means a check which is truncated during the course of clearing. So truncation system was actually included through a this RBI manual which was circulated, and it was through an experiment basis it was started, where in fact it substituted the further movement of a paper check for the purpose of clearing. So earlier the concept was the check used to reach the drawee banker for payment, and it used to be into the custody of the drawee banker. But then after this truncation system, it usually now is seen that the original paper check lies with the collecting banker. The collecting banker is the banker of the payee on whose behalf the payment is collected. So a truncated check means a check which is truncated during the course of a clearing cycle, either by the clearing house or by the bank, whether paying or receiving payment immediately on generation of an electronic image for transmission, substituting the further physical movement of the check in writing. So it helped in uh, stopping the physical movement of the check. Only the electronic image would go for the clearing purposes. Now, the most important thing, the definition, okay, happens to be very technical, but then there are certain things which we need to know beforehand. We go further, deal with the law relating to dishonor of checks. I've shown on the screen a picture where I have tried to show what all is there on a check. And you see, there are certain things which are required to be known very clearly. What are the things which are there on a check and which are very, very important? And they are, let me take one by one. On the extreme right on this picture of the check, you can see the date being mentioned. So date on the check is very, very important. Why? Because it is the date on the check. The date to which the check bears is actually important to calculate the validity of the check. It is from that date the validity would be calculated. And since we have the system of issuing of PDCs, that is post dated check, sometimes a check is issued to somebody with a post date. So in that case, the period of validity would be calculated on from the date which actually is mentioned on that. So if a check happens to be presented before that in the bank account, in the bank to the bank, then that check actually, will it be honored or not? It in fact would not be honored. In fact, it would be considered as, it would be in fact noted by the banker as good for payment. And it would only be considered as a bill of exchange. It will become a check only when it bears a date on that. So see the importance of date. Then the next important thing is on the extreme, since this check happens to be, the check leaf happens to be of SBI, and you can see the name of the bank printed here on the extreme left, that is State Bank of India. Now, the State Bank of India is which bank? As I just mentioned, there are three parties, that is the drawer of the check, the drawee of the check, and the payee. So, when I say drawee of the check, the drawee of the check is the State Bank of India. The name of the drawee bank is mentioned on the check leaf, and that in this case is the State Bank of India. So the drawee, name of the drawee bank is also there on the check. The date also is mentioned on the right, which is very, very important. Then the third thing, which is very important to be there in order to call an instrument to be a valid check, that is in whose favor this check is issued. See, this drawee banker is actually the party upon whom this check is drawn by the drawer, and the check actually is drawn to the favor of certain person. And the, if see here before the pay, here it is written teach lane. Instead of teach lane, if it is mentioned somebody's name, we say the name which is mentioned is called as the payee. That is this person payee. The name of the person will indicate the party, that is the payee, who actually is entitled to get this check encashed. So name of the payee should be there. So if no name is mentioned, what would be the status? Anybody, see, it's very risky. There is another added advantage is to write the check before it is issued to somebody in whose favor you are issuing the check. you need to write. If no name is written, anybody who comes in possession of the check can write his name and can get it encashed. So once nothing is mentioned on that, it becomes a bearer check. Or if the word bearer as such is expressly mentioned, that is pay the bearer, it becomes a bearer check. So whosoever would be in possession can get it encashed. But the question arises, initially I said the possession has to be lawful, and whosoever, if the person happens to be in unlawful possession, he can get it in cash, but there would be other difficulties which in fact would involve the negligence, which would involve the liability of certain parties. Because if the banker which encashes that check makes the payment or credits the amount into the account of the person who has presented the check, he would not be considered negligent. So, the bearer check here means a person should be in possession, but the possession as such which is required is lawful possession. Then the third thing, which is fourth thing, which is important, is the amount. See, the amount, as we discussed in the definition, that it is a bill of exchange, and a bill of exchange is what? It's an unconditional order directing to pay a certain sum of money. So this sum which has to be mentioned before the rupees has to be very specific. It should not be uncertain. If along with 5,000 rupees as mentioned here, something plus is added, that is one box or one pair of shoes, something, it would not be construed as a valid check. So it has to be a specific amount which has to be mentioned. And in a check, the amount is mentioned both in words as well as in figures. The words is mentioned in the second column after the pay, and there is a box on the extreme right where in words it can where in figures it can be mentioned. An important question which arises is, suppose if there is any discrepancy, that is amount in words which is mentioned is different from the amount mentioned in figures, which one would prevail? So as per the law, there has been cases where it has been settled that the amount in words would be considered as the amount payable on a check. Then there is a box where you find on the check leaf an account number being printed. At times it is printed. So in this case, it is printed. At times one can fill in that. And also these days we find validity of the check is also mentioned. Validity, the period of validity, that is whether it is 3 months, 6 months, or 1 year. Uh, as far as section 138, which talks about the validity period, it says 6 months or which any other period. So it may vary, but let me tell you, at present this controversy is over. We have, as per the RBI circulars, the period of validity is only 3 months. And you can also see the check valid for a certain amount. Some limitation at times may be prescribed. So in this case, you can see in the picture that the validity, the sum actually is laid down. If the check is drawn for more than amount, then it would hamper, affect its validity. It cannot be, it will not be honored. The next important thing is on the extreme right below, you find please sign above. So here, Mr. Deepak Das, who has signed here, is actually called the drawer of the check. And the drawer of the check would be valid only if once he signs that. Without signatures, it would not be complete. It would be considered as an inchoate instrument as per definition of section 20 under NI Act. Then you find certain things printed there just below. Let me also clarify that. I've tried to identify that what it has mentioned. You can see 6-digit number is there. So initially mentioning this 6-digit number is actually the check number. We are also on and off being called to mention our MICR code and IFSC code. So here MICR number, that is magnetic ink character recognition code, is also there, which is provided to every bank for recognition and identification. See, it's provided, it's a 9-digit number. And then the next you can find the number which is mentioned below is the RBI account number. And lastly, the number which is mentioned is the transaction code. So it's all for security purposes. So in a check, all these things are to be fulfilled. I had just mentioned the definition of check. The features of check are that it's a bill of exchange, it has to be drawn on a specified banker, it is always payable on demand, and as per the definition, through an amendment, it also includes an electronic image of a truncated check and includes a check in an electronic form. I've also described Section 7 of the NI Act details who are the parties to this negotiable instruments. And when talking about the check, there are three parties, that is the drawer. Drawer actually is the maker of a bill of exchange or a check. So when we are talking about check, drawer is the person who actually is drawing the check or making the check, or who actually is writing. And I just mentioned on the extreme right below, the drawer has to sign the check, and without his signature it would not be considered as a valid check. Then the second party is the drawee, and as I told you, in case of a check, the drawee is always a specified banker, whereas in bill of exchange it can be a banker or it can be any other person. So drawee is a person who actually is directed to make the payment. So the drawee banker, here I just showed you SBI bank check, and SBI actually is the drawee banker who actually is to make the payment, and the other name used is the either you call it as a drawee banker or the paying banker. Why? Because actually the payment is to be made by the paying banker. The third party is actually in whose favor the check is drawn. That is also mandatory to be mentioned on a check, that is payee. Who is the payee? Payee is the person who actually is named in the instrument, to whom or to whose order the money is by instrument directed to be paid. Now, coming to this chapter, after understanding what this check means, we now come straight forward to this chapter 17, which was actually inserted in the year 1988 by the Banking, Public, Financial and Negotiable Instrument Laws Amendment Act. And initially, this chapter consisted of sections from section 138 to 142, and via amendment made in 2002, it was further enlarged from section 138 to 147, and in 2015 there were certain additions amendment made in the existing act, but finally in the year 2018 there were certain amendments, and by which the number of sections were increased, and therefore at present we find chapter 17 consisting of sections from section 138 to section 148. Okay, as I just mentioned, whenever a check is issued and it is dishonored, it can it can be considered to have committed an offense, but it is not always. In order for an offense to have been committed under section 138, there are certain requisites which have been provided in this chapter 17 under section 138, and in order to understand that, I have come out with these requirements. That is when the offense under section 138 would be made out. So in order to make a person liable for offense under section 138, these following points are required to be proved. So we'll take one by one what are the requirements. The first thing is that the check should have been dishonored for the reason of insufficiency of funds, or for the reason that amounts exceeds the arrangement, that is under the overdraft facility. So if you see initially and at present also, this definition continues. There is no changes being made under that. That is, only two contingencies are attracted for making dishonor of check and an offense under chapter 17 under section 138. That is, the check should have been dishonored for the reason of insufficient funds in the account of the drawer, or because of the amount which is mentioned on the check exceeds the arrangement which the drawer has made up with his banker, that is the drawee banker. So only two contingencies. But then let me also have elaborated further that at present, due to various judicial pronouncements, even the account closed, refer to the drawer, or stop payment advice are also covered under the guise of this section 138. They are also attracted. And to go in length further, there are two landmark judgments which says that the cause of action is not dependent. This defense of insufficiency of funds cannot be availed by the drawer. Why? Because offense as such for bouncing of checks under 138 requires only when the payment actually is not made by the drawer within 15 days period which is provided to him. So coming back to the first requirement, as the section reads, the offense can only be made when the check has been dishonored for the reason of insufficiency of funds, or for the reason that the amount exceeds the arrangement under the overdraft facility. Then the second requirement which is to be seen is the check so dishonored was actually issued for the discharge in whole or in part of any debt or other liability. And this debt or liability has to be legally enforceable debt or liability. As I told you, since this NI Act has this law of presumptions and consideration is presumed, but presumption only leads to shifting of burden of proof onto the other party, that is onto the accused drawer. But what is important is it has also to be seen that whenever a check is issued, it should only be the story of the complainant, payee, or the holder in due course should be that he was issued check for discharge either in whole or in part of any debt or other liability. Thirdly, the check so dishonored must have been presented to the banker within the period of 6 months. As I just mentioned, at present, the period of validity is now 3 months through an RBI circular. But the definition still continues with that. There is no change in section 138. It still mentions that the check so dishonored must have been presented to the banker within the period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. And at present, the period of validity for all purposes is 3 months as per RBI circular. Next, see, there is, after the check is presented and it is dishonored for the reason of either insufficiency of funds or amount exceeding arrangement, and this check, if it actually is established, is for discharge of any debt or liability which is legally enforceable, and it was also actually presented within 3 months, that is at present 3 months, that is the period of validity. The next important step to in fact required under to make an offense under section 138 is a requirement of mandatory notice is must. So the next requirement, once this happens, what is required to be done is there is a requirement of, and this requirement is mandatory, a notice is required to be sent in writing. A notice in writing should have been issued, and there is a period provided when this notice can be issued. Now, as far as the practice is concerned, there are many technicalities which I'll try to take up in the end when I taking up the various features or while critically analyzing it. So, coming back here, notice in writing should have been issued within the period of 30 days. And when that 30 days period would start, that would start of the receipt of the information. Once this payee or the holder in due course, he receives an information that his check has been bounced, he receives a memo from the bank thereby mentioning that it has been dishonored for insufficiency of funds, the very next day this 30 days period would start, and within that 30 days period the notice in writing is required to be sent by the payee or the holder in due course. The question arises if the person fails to send the notice. So will there not be any offense? Can still the cause of action will not take place. This earlier was not allowed, that once this 30 days period goes off and the notice is not sent within that period, then one would fail would not be successful in filing a case under section 138. But now due to judicial Supreme Court judicial pronouncement with the landmark case on MS Leathers, it settled this controversy. It said since the check happens to be since the check can be presented before the bank uh, any number of times during its period of validity. So what one can do is, suppose once he presents the check, it gets dishonored and the person fails to issue the notice within 30 days period on the receipt of the information from the bank. What he can do is he can simultaneously again present the check and get it. If it still is dishonored, he can afresh renew that 30 days period and can set the notice. But earlier it was not so. So a landmark judgment of Supreme Court came, that is MSR Leathers versus S Palaniappa, and that I've mentioned later in this slide also. The next requirement is such notice. It's not simply an application which is written. So there are certain legal requirements. There are technicalities which are to be seen before a notice is sent. So it is advised whenever a notice with regard to bouncing of check under section 138 is to be issued, a lawyer should be consulted, because he has to see other requirements, those specific things as per the law is required. And since I'm making you aware, I think so you would also can make use of that. So such notice should specifically allege that dishonor of check for reason of insufficiency of funds, and also specify that the notice is issued under section 138. So specific mention has to be there in the notice. If that is fake, it may still hamper, but then we have certain cases where they have been dismissed also. Uh, then the next requirement is the notice should state the date, the details of the check which is dishonored. They are very, very important. So notice in writing should state the date, the check number, the name of the drawee banker, the amount for which the same is drawn, and the date of issue of the check in case the check is post dated, or if the check happens to be antedated, that date of issue becomes very, very important to be mentioned. Then apart from the details of the check, what further is required to be mentioned in the notice, that is, notice should also mention the consequences the accused may be held liable to face, and there should be a specific demand of the amount of the check. ऐसा नहीं है कि आपने अमाउंट डिमांड नहीं किया, स्पेसिफिक डिमांड. So that is why we call it that is a demand notice is mentioned. So specific demand of the amount has to be mentioned in the notice. Next, the drawer of the check so dishonored should have failed to make such payment within the period of 15 days from the date of receipt of notice. So it's not simply that you present a check that is dishonored, and that is dishonored, mentioned in the memo which is issued to you by the bank that it is insufficient funds, and after receiving that information you just send a notice to the drawer, and with fulfilling all the requirements you ask him to make the payment. You cannot immediately after sending that notice to him for demanding that amount of the check can straight away file a complaint case in the court. You have to wait for 15 days. So once the notice is issued, and if the payment is not made within 15 days time from the date of receipt of notice, कहने का मतलब ये है कि ड्रॉर को जब नोटिस मिल गया, the count starts from that day. That is, 15 days would be counted after he has been the very next day. Suppose if the drawer gets a notice today, so today is 17th, the counting would start on 18th. 18 September. So 18 September, or in total 15 days, the payee has to wait, and then he would be given 1 month's time. So next requirement is, once the 15 days period passes over and the payment is not made to the payee or the holder in due course, then this payee or the holder in due course can file a complaint within the period of 1 month. So this period of 1 month again is also very, very important. No doubt there is a provision in this chapter 17 of condonation of delay, but that condonation of delay will only be provided the court is satisfied that there is a sufficient cause for delay. So the complaint should have been filed after waiting for 15 days. 1 month period is provided to the payee or the holder in due course to file the complaint. That is, on the 16th day, when the payment is not made, the cause of action arises and the complaint can be filed by the payee within 1 month. And this period can be extended provided there is condonation of delay if some sufficient cause is being shown to the court. The next important thing is who can file a complaint. So as per the law, the person should have a locus standi. So complaint should be made. Who has a locus standi? Complaint can only be made by the payee whose name is mentioned on the check, or the holder in due course who actually came in possession of that instrument as a holder in due course in writing. So complaint has to be in writing, and only the payee or the holder in due course has the locus standi to file the complaint. Next, where to file this complaint? The complaint should have been filed before, at least in a metropolitan city, before the metropolitan magistrate or a judicial magistrate of first class. So complaint should have been filed only before the MM or a judicial magistrate of first class. So these were the requirements. There are certain things which I would like to discuss where we have certain cases, and because of these judicial pronouncement, various things have been decided, because these judgments happens to be coming from the Supreme Court, and as per Article 141 of the Constitution of India, whatever the Supreme Court decides is the law of the land. So that is also equally good law, which is applicable on everyone. So suppose the case happens to be that the check which was issued, or like we can say the check which was issued and which was dishonored for the reason of insufficiency of funds, was of 10,000 rupees, and only out of 10,000, 2,000 has been paid by the drawer. So can that part payment made by the drawer will affect the filing of the complaint? It has been settled that the part payment made will not affect the filing. Still, the complaint can be filed under section 138, making dishonor of check as an offense. As I just mentioned, what would be the effect if suppose the payee or the holder in due course fails to send a notice, issue a notice in writing within the period of 30 days, which is provided? In that case, multiple presentment of a check will not affect the legal validity of the notice. So what is the option available is you can present the check again, provided it is within 3 months, which is actually at present the validity period of a check, and it is counted from the date which actually is there on the check. So multiple presentment of a check will not affect the legal validity of notice. Check can be presented any number of times during its period of validity. And the period of validity is calculated from the date which the check bears. And as I told you, the landmark case is MSR Leathers versus S. Palaniappa, which was decided by the Supreme Court in 2013, which held that the prosecution which is based on the second or a subsequent notice was valid. And I also mentioned about the post dated check. What is the status of post dated check? If suppose a post dated check is issued and thereafter it is presented, no doubt within the period of its validity from the date it bears, and it gets dishonored, will it hamper? See, as such, PDC is considered as, that is, post dated check is considered to be only a bill of exchange. It becomes a check on the date it bears. So the period of validity would be seen to be calculated from the date actually it bears. And 138 covers even the post dated checks also. I had mentioned with the very first requirement, that is on what grounds this offense under 138 would be made. Section 138 specifically covers only two contingencies, that is insufficiency of the funds in the account of the drawer, or the amount exceeds the arrangement under the overdraft facility. But as I just said, these two contingencies are mentioned. But as I told you, there are many judicial pronouncements, through various judicial pronouncements of the Supreme Court. Even stop payment advice, account closed, refer to the drawer have also been included to make offense under Section 138 with respect to the bouncing of checks. But at that time, earlier, before this 2010, it was that account of the drawer, that the funds in the account of the drawer should be sufficient. And it was mentioned that 138 can be taken up, can continue. And at the time of trial, it would be seen whether it was sufficient or the funds were sufficient or insufficient in the account of the drawer. But with the latest pronouncement of the Supreme Court, these two pronouncements become very, very, and they endorse that uh, sufficiency of funds cannot be a defense which can be raised by the accused. So in Rangappa versus Mohan, which is a Supreme Court decided case in 2010, this was held. And the latest case, Supreme Court in this Lakshmi Daichem case, it explicitly, in fact, covered, it stated that all possible endorsements on the returning member of the check. So explicitly, Supreme Court is stating that now explicitly covers all possible endorsements on the returning memo of the check, stating that the cause of action, the reason given by the Supreme Court was that the cause of action accrue not on the dishonor of check simpliciter, कि check dishonor हो गया, इससे accrue नहीं होता है, and nor does it relate to even reason for the dishonor of check, the reasons which, that is insufficiency or amounts exceeds, but it accrues only on non-payment of the check amount within the 15 days time which is provided to the drawer from the date of receipt of the notice. Why? Because why this 15 days time is given? Why? Just to see if the drawer is an honest person. He is given sufficient opportunity before a complaint is filed against him to make the payment. So no excuses would be heard later on. Then most important issue which was highlighted was with regard to jurisdiction of the court. As I said, which court will have, it would be the MM or the judicial magistrate of first class, but which place the case can be filed. See, there was a landmark judgment that is in Dashrath Roop Singh Rathod case. There was lot of uncertainty, there was lot of turmoil, and there were many transfers thereafter, followed by two ordinances. And finally, this uncertainty was set at rest with regard to jurisdiction of the court via Negotiable Instruments Second Amendment Act brought about in the year 2015. And with this amendment, Section 142 Clause 2 was inserted, and 142 was renumbered 1, and 142 Clause 2 was added. Now, let me read out what this Section 142 Clause 2 specifically provides. The offense under Section 138 shall be inquired into and tried only by a court within whose local jurisdiction A, if the check is delivered for collection through an account. Now, what does it refer to? If the check is delivered for collection through an account, that means the check is a crossed check. So when a check is crossed, it can only be collected through an account. It cannot be collected from the cash counter of the drawee banker. If the check is delivered for collection through an account, that is a cross check, with the branch of the bank where the payee or the holder in due course, as the case may be, maintains the account is situated. तो जहां पेई एंड होल्डर इन ड्यू कोर्स का अकाउंट है वहां की ही jurisdiction बनती है. For example, let me take, I have an account with SBI Delhi University branch, and I have been issued a check by Mr. X to me, and it gets dishonored. After the information I received from the bank with the memo that it is for insufficiency of funds, I issue a notice to him within the period of 30 days after the receipt of notice, after the receipt of information from the banker of dishonor, and then waiting for 15 days time after the information has been received by the drawer Mr. X. On the 16th day, I, within the period of 1 month, file a complaint. So where would I file a complaint? Since I am the payee, the check, Mr. X had issued the check to me, I being the payee, I would file a complaint only where I have my account. So since my account is here in Delhi University branch, it would be Tis Hazari which would be having jurisdiction to decide upon. And only when the check which was issued by Mr. X to me was a crossed check. Clause B to section 142 clause 2 provides that if the check is presented for payment by the payee or holder in due course otherwise. Now what does this otherwise means? That is, if the check happens to be an open check, that is, it is not crossed, then it can be through an account, the branch of the drawee bank where the drawer maintains the account. अगर तो ओपन चेक है, क्योंकि ओपन चेक कैन बी इन कैश डायरेक्टली in the bank of the, has to be encashed from the bank where the drawer actually is having an account, and that bank is called as the drawee banker or the paying banker. So straight away, what if I'm issued a open check, I would straight away go to Mr. X bank where actually he is having an account. The problem today is we are having core banking, and that is payable at par. So there are many, SBI has many branches everywhere. It's not that I can go to any branch and depending upon that I can choose jurisdiction of any court. It's not that. So this controversy is finally been settled that in case if it happens to be a cross check, then in that case where the payee or the holder in due course is actually maintaining the account, only jurisdiction of that court, because there is the Delhi is divided into various zones, and as per the zone in whose area that branch where the pay is having account would be covered, falling into, only that court will have the jurisdiction. And if the check happens to be an open check, then in that case it would always be where the court within the jurisdiction, the court where in fact the drawee banker actually is, that place will have the jurisdiction. There was a new amendment made in this chapter 17 that was in the year 2018. That's the latest amendment we see made to this Negotiable Instruments Act under chapter 17, thereby insertion of section 143A and section 148 being inserted. Referring to this section 143A, it talks about interim compensation. That is, it was seen that the payee or the holder in due course being harassed because of this bouncing of check. So therefore, this new way to compensate him, a provision was added, that is, power was given to the trial court to direct for an interim compensation. Meanwhile, the case gets decided, he is provided with certain compensation just to ease his burden. So section 143A clause 1 says, notwithstanding anything contained in Code of Criminal Procedure, the court trying an offense under section 138 may, Now, here the word may, in fact, is very important to be understood. May here is that it is not in all cases it would be. It, in fact, is with regard to the discretion of the court, but certainly the discretion which is exercised by the court is not an arbitrary discretion. It has to be within the scope of law. He has to justify and give reasons why he is giving an ordering the interim compensation and why not. So he may order the drawer of the check to pay interim compensation to the complainant in a summary trial or a summon case. Because if you see, this chapter 17 provides for a summary trial or to proceed with the case as a summon case, where in those cases where the drawer pleads not guilty of accusation made in that. So if he wants to hang on further, who would be harassed? It would be ultimately the payee or the holder in due course. So this provision was just to ease the burden on the burden of the complainant. So it can be directed, but of course it is a discretion of the trial court. Clause B, in any other case upon, so it can be in any other case upon framing of charge. Initially, it can be when he's not pleading guilty, when he pleads not guilty, or at the stage of framing of charge. Clause 2 says, suppose the interim compensation as mentioned under subsection 1 of section 143A is there. There is a limitation provided. The trial court shall not exceed. Kitna compensation de sakta? He cannot exceed 20% of the amount of the check. So it has to be as per the amount of the check, and certainly it cannot exceed beyond 20% of the amount of the check. And what is the time given to the accused drawer? The interim compensation shall be paid within 60 days. So 60 days time is given, and that 60 days would be counted from the date of order. आज order हुआ है तो कल से 60 days count हो जाएंगे. Or within such period not. If 60 days period is not sufficient, if some more period is required, so that can be there, but only in exceptional cases when the court on sufficient cause being shown, it can further allow certain more days, but certainly not exceeding 30 days. So 90 days के beyond तो कभी जा नहीं सकते, so it should be within the 30 days. The question arises, suppose when the trial takes place before the court and the drawer of the check is acquitted, instead of conviction he is acquitted, what would happen with regard to that interim compensation? So they have thought about that also. So clause 4 to section 143A states that the court shall direct the complainant to repay to the drawer. अब वापस देना पड़ेगा to the drawer the amount of interim compensation, but सिर्फ amount ही नहीं देना पड़ेगा. It should be along with the interest at the bank rate. What rate? At the bank rate as published by the RBI, prevalent at the beginning of the relevant financial year. And similarly, he would also be given 60 days time, and further extension up to 30 days would be provided there is sufficient cause which is shown by the complainant. And whatever this interim compensation which is payable under this section, it may be recovered as if, isko recovery kaise ki ja rahi hai from the complainant, as if it was a fine under section 421 of the CRPC. And this amount of fine which is imposed under section 138 or the amount of compensation awarded under section 357 of CRPC shall be reduced by. तो जो compensation होता है उसमें से उसको reduce, अगर award किया जाता है तो उसका reduction हो जाता है, जो कि 138 में double the amount and remedy is provided. Then section 148 was also inserted in the this 2018, thereby insertion of section 148, which states that notwithstanding anything contained in CRPC in an appeal. So whenever an appeal is filed by the drawer, suppose conviction kar diya trial court ne, and now this drawer wants to go in appeal before the superior court. So in that, he cannot simply after conviction go and knock the doors of the court and challenge it. Why? Because it would further harass the complainant in that case. So therefore, there is a provision that if he wants to appeal against the conviction under section 138, the appellate court again is having a discretion. The word used is may. He may order the appellant to deposit such sum which shall be a minimum of 20%. So यहाँ पे भी मिनिमम दिया है, वहां तो मैक्सिमम 20 से बियॉन्ड नहीं जा सकते, यहाँ मिनिमम जो है 20% होगा, वो किसका? 20% चेक अमाउंट का नहीं, 20% ऑफ द फाइन और द कॉम्पनसेशन विच इज अवॉर्डेड बाय द ट्रायल कोर्ट, प्रोवाइडेड that the amount payable under this subsection shall be in addition to any interim compensation paid by appellant under. ये नहीं जस्टिफिकेशन होगा कि हमने 143A में interim compensation दे दिया, why I should pay this compensation now for filing an appeal. So it would be in addition to the already interim compensation paid by the appellant. Clause 2 to section 148 states that the amount which is referred to in subsection 1 shall be deposited. So again, the time period which is given for depositing that interim compensation is 60 days time, a further extension of 30 days, provided satisfaction of the court, sufficient cause is there shown to the court. And the appellate court may direct the release of amount deposited by the appellant to the complainant at any time during the pendency. जो ये deposit करेगा appellant draw, that amount would be released to the complainant any time during the pendency of the appeal by the appellant. Deposit पहले court में किया जाएगा और फिर and then appellate court would release that amount during the pendency of the appeal. Provided, now there is again a condition. Suppose if after the appeal the appellant is acquitted, what would happen? This amount which is deposited as an interim compensation at the time of filing an appeal, that would be again directed to be paid back. So complainant is to repay that appellant the amount so released, and with interest at the bank rate which is published by RBI at prevalent at the beginning of the relevant financial year. He would further be given 60 days time and another extension further of within 30 days, provided he is having sufficient cause to be shown to the court to its satisfaction. A very important thing which is required to be understood is whether this offense which is made out under section 138, once a complaint is filed, can it be compounded? Compounding of an offense was permitted earlier also before the insertion of section 147 via amendment made in the year 2002. But specifically section 147 made it very specific clear, thereby providing that notwithstanding anything contained in the CRPC, every offense punishable under this act shall be compoundable. So it's a compoundable offense. If both the parties are willing to compromise, they can enter into a compromise and can withdraw the case. But the question arises, an offense is compoundable provided both the parties are giving consent to it. Suppose accused is willing to compound the offense, is willing to pay to the payee or the holder in due course, but the complainant, that is payee, is not willing to do so. So the question arises, can the accused seek compounding on offense for check dishonored without the consent of the complainant? क्या वो compound कर सकेगा जिसमें the complainant is not willing कि नहीं, he feels I was harassed and he should be punished, so I am not willing, even if he pays me now, I'm not willing. On this point, there is a lack of clarity as per the judicial pronouncements. We had we earlier had, before these two latest pronouncements in the year 2012 and 2018, we had this case in Damodar S. Prabhu versus Sayyid Babalal in 2010. Actually, Supreme Court had laid down certain guidelines for compounding the offense under section 138. And guidelines were laid down, but actually did not touch upon the issue whether compounding can be done even without the consent of the complainant. So the case in JIK Industries Limited versus Amarlal versus Jumani in the year 2012, the division bench of Supreme Court held that the consent is necessary for compounding of offense under section 138. तो यहाँ डिवीजन बेंच 2 जजेस बेंच ने, सुप्रीम कोर्ट ने तो ये डिसाइड कर दिया कि कंसेंट तो जरूरी है कंप्लेनेंट जो कि पेई और होल्डर इन ड्यू कोर्स है. Whereas in Meters and Instruments Private Limited versus Kanchan Mehta, in the year 2013, the division bench, two judges bench, it decided, and it gave a more progressive approach, thereby permitting that accused to the compound an offense by paying the check amount. So that means even though the consent was not given by the complainant, still it was, the accused was permitted to compound the offense. So that seems to be which law is to be followed, whether JIK industries ratio should be followed or it's a meters instrument. So this that is why I just mentioned there is a lack of clarity, and it requires, this issue requires to be mentioned, brought before a larger bench. And once this is done, so there would still be a confusion with regard to it. Another thing which becomes very, very important is, that is, can the check bounce cases be instituted or be continued against companies which are facing insolvency proceedings under Insolvency and Bankruptcy Code 2016? So, in fact, there was a Supreme Court case. I just could not recall that in a very short time, but if those who are interested, I can let them know later on. In March 2021, the Supreme Court held that the check bounce case neither be instituted nor be continued against, institute nahi kar sakte, and if it existed, it will not continue against the companies facing insolvency proceedings and are protected under Insolvency Bankruptcy Code, thereby putting a moratorium as legal proceedings against them. But whereas this benefit is only with regard to the company, but this benefit of moratorium is not extended on judicial proceedings in check bounce cases to directors or signatories of check of such firms, stating that criminal cases would continue against them as a natural person. So company artificial hai, uske khilaf to rok diya, but with regard to the directors or the signatories who were responsible for that, they criminal proceedings against them under section 138 would still continue. Why? Because they are natural persons. And this institution or continuation of proceedings under section 138, 141 dealing with companies under NI Act can set to be covered under section 14 of IBC. Now, what was the basic object to cover them under section 14 of IBC? The object was to see that there is no depletion to the corporate debtors' assets. So once that insolvency resolution process starts, thereby a moratorium with regard to legal proceedings against the company cannot be continued. The very, very important thing, the law is there, but since rights have been provided under this law, but the question arises on breach of that, violation of the law, what are the remedies available in case of dishonor of checks? And generally, whenever a check is dishonored, there are twofold remedies, one categorized under civil remedies, the other are criminal remedies. Civil remedies, what are the options available to the payee whenever his check is dishonored for reasons of insufficiency or otherwise, or for any other reason, he has an option to go in for an ordinary suit for recovery of amount. And this procedure existed long back, but then why we had to have other remedies, civil remedy, that is in the form of summary procedure? Why? Because under summary procedure, the procedure is summary, summarized, and it's not lengthy. So the drawbacks in this remedy of filing an ordinary suit for recovery of amount had these drawbacks. One was it required a court fee to be submitted. Agar it was a hefty amount of check, then it's to claim a remedy, one needs to file a court fee depending upon the valuation of the suit. The suit is valued on the basis of the amount of the check. So it was a burdensome process. So requires court fee to be paid. Then lengthy procedure, as I told you. And it was not there was a lack of coercive process. It was not an forceful process ki nahi diya to one could go free. What are the options available? And it actually proved to be failure to recover practically. Recover hi nahi ho pata tha. That is why this summary procedure was most opted as a civil remedy. And along with that, it required, agar ho bhi jata tha, to it required execution petition. it needed execution. To execute the order, it required execution petition to be filed. So the second civil remedy which is provided is summary procedure under Order 37 of CPC. Similar things were there, but then the procedure was cut short. About the criminal remedies, in case of bouncing of check, in an offense of cheating under Section 420 IPC could be filed through FIR, but it's not an easy task. Why? Because mens rea as an essential element of crime, it required mens rea to be proved, which in fact proved to be very difficult. If it could be, then the punishment certainly was very grave. That is, punishment up to 7 years could be given. The most effective criminal remedy appears to be under Section 138 of NI Act. This remedy is speedy, it is economic, simple, and specialized. And this remedy can be availed for dishonor of checks, but only more particularly for insufficiency of funds in the account of the drawer. So we have understood what is the things under the entire law relating to dishonor of checks. But the most important thing is right from step first, what is required. So I have quickly refreshed what is the procedure to be followed in case a check is bounced under Section 138 of the NI Act. So the first thing to be seen is the check should be presented within its period of validity. Second is check should be returned dishonored with returning memo issued by the banker, which is considered to be a certificate. Then issuance of a demand notice within 30 days of receipt of dishonor, thereby giving 15 days time to make the payment. And the cause of action to file complaint would start on the 16th day, thereby waiting for 15 days. The 16th day, the cause of action for filing a complaint would start of the receipt of notice by the drawer addressee. And then once that is there, filing of complaint has to be done within the period of 1 month after the accrual of cause of action. Condonation of delay is there, but then on the basis of, is permitted, but on the basis of sufficient cause being shown to the court. Once the complaint is filed, either along with the complaint, affidavits are filed for tendering pre-summoning evidence, either, as I told you, with the filing of the complaint, or those affidavits for pre-summoning evidence can be filed next day after the filing of complaint. And then if the court is satisfied, the summons are issued to the drawer accused on the satisfaction of the court. That is, when the prima facie case is made out after going through the pre-summoning evidence of the complainant, the court would issue summons to the drawer accused. And if no case is made out, no prima facie case is made out, what the court would do, it would dismiss the complaint summarily. Then once the summons are issued to the accused drawer, what the accused does is, accused will appear and seek bail as a right. Why? Because it's a bailable offense. Then issuance of court notice in the nature of charge under. अब ये देखिए, it's just lengthening the procedure. कि यहाँ पे he's taking the summons. It is not there and then everything is done simultaneously. This is actually a drawback which I highlighted in my research work. See, summons दे दिया, summon के बाद now he would apply for bail, and then issuance of court notice, a charge would be framed. Why not the same very day when the drawer accused appears before the court? All these things can be done together. So issuance of court notice in the nature of charge under Section 251 CRPC and decision on interim relief is there under Section 143. Now, these three stages can be cut short had it been the same very day when the drawer actually presents himself after the issue of summons. Then, as per the Evidence Act, prosecution at first, it is the prosecution evidence will be led, and this prosecution evidence would be by adopting the affidavit which he has already initially filed on record at the time of filing of complaint or the next day, which is followed by cross-examination. Let me tell you, how the evidence actually is taken before the court is that the party who initiates the proceedings in case of since this 138 is a criminal case, so therefore we call the party who initiates the proceedings as a prosecution. So prosecution is first given the chance to examine the witness. There is in fact which is followed by cross examination, and if the need be re-examination. So there are three stages by evidence from the side of prosecution. That is examination in chief, that is prosecution evidence is led by adopting wo affidavit dega, evidence dega, that is called as examination in chief. The counsel of the prosecution would put questions with regard to it, which is subsequently followed by cross examination by the counsel of the opposite party. Here it is the accused drawer. And then after that cross examination, the opportunity to the other party is given, his statement is recorded. Why? Because we have under Indian legal system an adversary system, so it is opportunity given to both the parties to state what they want to. So first opportunity was given to the prosecution to adduce the evidence, which was subjected to cross examination, and then comes the turn of the defense defense of the accused. He would give his statement, he would record his statement, and that statement is recorded under section 313 of CRPC, where he would disclose his defense. Then a defense evidence, he would be given a turn, he would lead his or evidence, either he would give orally, he would explain, or he would submit affidavit with regard to it. And then his turn for a cross examination, accused is cross examined by the counsel of complainant, क्योंकि cross का मतलब है counsel एक दूसरे के opposite को cross examine करते हैं. So accused is subjected to cross examination by the counsel of the complainant. And then once this stage of evidence is concluded, final arguments, after the stage of evidence there is final arguments, and then it is decided whether there is a conviction or acquittal of the accused. And then argument, what sentence to be given, there are arguments on the sentence in case of conviction. The sentence will be pronounced, and immediately accused is arrested instantly. I can find some disturbance. Sentence will be pronounced and the accused arrested is instantly. And once he is arrested, he would instantly be released on bail by filing till filing of an appeal. And then he gets an opportunity to file an appeal before the appellate court, and appeal is filed by the accused. And as I just mentioned, section 148 also provides for a provision of interim compensation to be deposited by the accused. So this was all with regard to law relating to dishonor of checks, that is paper checks. Now coming to the other, that is at present we find there are fashion of electronic transfer of funds. So this electronic funds transfer are legally made enforceable with the enactment, as I just mentioned earlier, that under the Payment and Settlements Act 2007. So this Payment and Settlements Act 2007 actually governs the electronic transfer of funds. Any dishonor of this electronic payment is governed by this Payment and Settlements Act 2007, and it has section 25, which actually is pari passu with section 138 of NI Act. So similar, you have a provision under this Payment and Settlements Act 2007. And with the introduction of this various payment systems in India, now the money can be transferred online easily from one bank to another. And for this transfer, we have various options which are available online. That is one, the immediate payment system, that is IMPS. Then we have National Electronic Funds Transfer, that is in short called NEFT. Then we have real-time gross settlement, that is RTGS. Briefly about the features, but this was not the topic, but then I thought about to draw a comparison. This IMPS, basically here the funds, transfer of funds is completed immediately, and transfer of money can take place 24/7, and it can be completed by using either internet banking or mobile banking. And actually various digital banks in India, they use this IMPS to transfer money. But there are certain charges also being levied, and the transaction charges, they may vary from bank to bank. Whereas with regard to NEFT, the transfer of funds from one bank branch to another bank branch, which is actually participating under the scheme, is there. NEFT transfer of funds takes longer as compared to IMPS. Then we have another mode, that is RTGS, that is a real time gross service system, mainly used for higher value transfers, which is required immediate clearance. And that actually is completed only during hours. So it's more preferred one in comparison to NEFT. Thank you so much. Over to you, JP.
Okay, the floor is open for the some query. If anyone have, please feel free to ask.
Can I ask a question, ma'am?
Sure.
See, suppose these days, when we go ahead, people stand in as guarantors,
Mm-hmm.
and they give usually an unsigned check, a signed check which is not dated,
Mm-hmm.
and not even an amount is given there. But there is an understanding as to how much amount can be filled in.
Mm-hmm.
So suppose the original person who has taken a loan, they default,
Mm-hmm.
and this check is, of course, is in the name of, is the drawee is the guarantor who hasn't taken the loan, incurred the loan.
Mm-hmm.
So because of the default of somebody else, you end up paying. Now you can be taken to court, and is there any way that one would be able to kind of
Actually, can you just repeat? I couldn't get you. I was trying to,
these days when people are buying things, they take loans.
okay.
All of us take loans,
Uh,
normal.
uh,
But when the loans are bigger and people do not have means, they get their friends to stand as guarantors.
sure, sure.
And I think we have seen this happening in our society because a lot of people are aspiring for a lot of things. So
Hmm.
friends also, in their good sense, they stand guarantors,
Hmm.
and the company requires them to pay to give a check, a signed check, but which is not dated, and the amount is also not written in there.
Hmm.
Okay, so
Uh-huh.
then in these cases, because the person who has taken a loan is not able to pay back, so the
Hmm.
guarantor has to pay.
Sure.
And
Hmm.
suppose the guarantor doesn't have money, it may be so that the guarantor also doesn't have money at that particular point of time, but the guarantor is usually dragged to the court, and the person kind of goes scot free. So, is there anything to safeguard somebody like this from law? Some safeguards which may be there.
See, the very fact that he has become a guarantor, there is no issue of safeguarding him. He actually willfully took the responsibility to pay back. So once the person who actually took the loan fails to make the payment, immediately he is to be caught. He is to be held responsible for that, na?
Yes, absolutely.
So why you want them? Why you want that he should not be? See, there you need to understand. Suppose A takes loan from B,
Yes,
okay, and the guarantor is C, okay.
yes.
Now A fails to make the payment, so here we are involved with threefold. Contracts are there. There is a contract between A and B where he has actually asked for a loan, and the loan is given to him on a guarantee that C would pay back if he fails to make the payment. It is willfully done. So suppose if A fails to make the payment to B, C actually comes into the picture. Why? Because there is a contract with the B and C. There is a separate contract. So there is also a privity of contract in which he can be held liable to make the payment.
Okay, fine. Yeah, I
and
understand.
and let me tell you, if this is forced to make the payment, certainly he is given a right to claim back that amount which he has taken the guarantee of from A. who
Okay.
actually has taken the loan. So
All
in
right.
that
Thanks a ton.
he's solely whole solely responsible for that. He can he his rights are also guarded through a separate contract. There are threefold contracts. One
Okay.
contract between A and B, another between B and C, and the third is between C and D.
All right. Thank you so much. Thanks.
Mhm.
Okay, I think that since that session by the Professor Gunjan Gupta was so enriching experience that almost of the questions already answered in her presentation. So I thanks to you, Professor Gunjan Gupta, on behalf of all the participants for your and for valuable time, giving this valuable time. Thank you so much. We will see. Looking forward for here another on another occasion. Thank you, ma'am.
Thank you so much. Thanks to you all.
Okay.
And in case there are any queries from our colleagues, if they are reluctant to ask here, they can contact me. My number can be taken from anyone, you know.
Okay, I will share the Professor Gunjan Gupta number in the group. So if anyone want to consult with ma'am, so you can consult. Okay, ma'am. Thank you, ma'am.
Thank you so much.
Okay. So now we are a little bit late, but still I'm sharing the attendance sheet link in the group chat, and we will start the next session at after 2 minutes. So in meanwhile time, please fill the attendance sheet for the this first session of the day. Okay, we will meet at 4:46. Thank you. With us, there is Dr. Aarti Aneja. Yes, ma'am.
Yeah, good evening, JP.
Good evening, ma'am. Okay, so the Dr. Aarti Aneja will take the session on the consumer law. And before I request to the start, let me introduce with Dr. Aarti Aneja. Dr. Aarti Aneja holds her PhD from the Faculty of Law, University of Delhi in Corporate Criminal Law. She has delivered endowed lectureship and leading university and served on editorial boards of learned journal in several jurisdictions. Her research interest dwells upon corporate and business laws. She has extensive research experience and has a number of publications in various journals, both home and abroad. She has presented several papers at various seminars and conferences. Her area of interest is corporate and business law, including company law, competition law, corporate management and corporate social responsibility, corporate finance, consumer protection law, law of contract, special contract, banking and insurance law, etc. So now, without taking much more time, because we are a little bit late, now I invite the Dr. Artyaneja to start the session.
Thank you so much, JP, and good evening, all of you. So the task has been given to me to share my views on legal views on consumer protection laws in India, and I'm just sharing my presentation. It's quite bulky presentation since I personally feel this consumer protection law, specifically if we talk about consumer laws. So consumer laws are having day-to-day life exposure. So to understand this law, you just need to have a look on certain uh, real experiences. So I'm just sharing.
Dr. Tarjis, please mute yourself.
Yeah, JP, it's visible.
Still not visible.
It's not visible.
No. Yes, can anyone see that? Any other? Shruti, can you
No,
see it?
sir.
No, it's not visible.
Okay.
No,
Let
it's
me
not
try. Actually,
visible.
this is very first time I'm trying on Google Chrome. Earlier, I used to work upon Safari. So there is some problem with regard to cookies. So let's see. I'm just trying. Uh, I'm just sharing a entire screen
Please share the window.
window. Okay. No, I think so. It's not working.
Share window, select the uh, window which you want to share, and after that, click on share.
Okay. Not entire screen, right? JP, it's not functioning properly. So what I can do, I can just mail you or what to do like. Um,
You can also try with the sharing the entire screen if you go.
but this is not functioning properly. This is the very first time I'm encountering such kind of problem.
Okay, please email me. I am doing.
Uh, Wait. Internal error with the system. So I'm just sharing this file with you,
Okay, okay,
but you have to be cautious because it's a lengthiest PPT which I can make.
okay, no issue.
So I'm sharing it on a Google Drive.
Okay,
I just need your mail ID for this. Okay. To see this.
yeah, I received.
No, 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 my mail. So let's see. I'll try like this because I don't have any option.
But this is good enough, ma'am. This is good enough.
Okay,
Yeah.
perfect.
Yeah, yeah,
Check.
yeah.
Thank you so very much. Uh, my topic is about a consumer protection laws. Consumer Protection Act 2019, I'm covering in this. And all of us are consumers. I'm just, I have prepared this slide just to keep this thing in my mind that I'm teaching to us participants who are from a non-law background. So I have tried to use certain pictures, certain graphics to make you understand the basics because this particular law is having a different kind of dimensions. So to cover all the dimension in a one go is quite difficult task. But still, uh, all of us are consumer. As all of us go to the market and purchase product, this is irrespective of the fact that we buy salt for rupees 20 or a small television for 50,000. It is a legal as well as a moral duty of seller to provide quality product to their consumers, and it is the right of a consumer to buy products of a good quality. Various laws, rules, and regulations have been put into practice to protect the consumer rights. Providing bad, tampered, adulterated, duplicate product is a violation of consumer rights. This may lead to legal action, and the seller producer may have to pay a huge compensation amount. If we talk about the consumer movement, so the movement in India as a social force originated with the necessity to protect and promote the interest of consumers against the unethical and unfair trade practices. This movement aimed to fight bad practices such as black marketing, adulteration of food, and misleading advertisement, restricted trade practices. So the consumer rights were legally first time recognized after the enactment of Consumer Protection Act (COPRA) of 1986 by the Government of India. What is the concept of consumer rights? If we talk about the concept, so around the globe, it has started quite early. Like practically, it was not in existence in 18th century worldwide, but in 1962, the Consumer Bill of Rights by the U.S. Congress was enacted. So this was the first legislation with regard to consumer per se. And in India specifically, so there are three eras. I think you all are, some of you are from economics or history. So there's a pre 1950 era where there was basically, if you talk about this particular slide in which ancient, medieval, and pre-independence era, if we talk about this, so there was certain sentiments with regard to unfair trade practices, price control, and that was a time of monopoly basically. And if we talk about 1950 era, prior to that, consumer were basically scrutinized in the hands of Britishers. So things were quite topsy turvy in that time. And once we got the independence in 1950 after constitution law, we started a movement with regard to consumer protection. And in a post-independence era, so this was the time in which our directive state principles in the Constitution of India. So the government promise that they will definitely take care of consumer movement, they will protect the rights of consumers, and they will control basically this monopoly trade practices. So that time there were two basic laws. The first law was a consumer protection law, which was enacted in 1986. Prior to that, there was a law, first law of which is known as a first Indian law of a consumer law, which was the monopoly restrictive trade practices. So that monopoly restrictive trade practices was against the monopoly, because uh, if a, if a wealth will come in a certain hands, so definitely they will misutilize that particular strength. They will basically use certain untrade and MRTP activities just to exploit the consumers. So that's the reason we basically enacted a separate legislation with regard to consumer protection in 1986. If we talk about the post 1986, so there was two act. First act was Consumer Protection Act, and second act was Competition Act. So this slide basically talks about consumer laws in India. So deliberately, I have not taken the Competition Act 2002 because it's quite technical in nature. But since I have given a choice that you have to teach consumer protection. So in consumer protection in India, there are two laws. First law is a competition law 2002, and second law is a Consumer Protection Act 2019. We are quite lucky that recently there is a major amendment in a Consumer Protection Act. It's not an amendment, it's a completely revamp of the act. Competition law is a basically revamped act of MRTP Act. So MRTP Act जो आया उसको डिलीट कर उसका रिपील करके Competition Law 2002 came into force, and in the same way Consumer Protection Act 1986 को completely हटा के it's a new act, Consumer Protection Act 2009. Because at that point of time the definition of consumer was this only कि आप being a consumer you're going somewhere and you are purchasing something and you are becoming a buyer, right? That was a time caveat emptor was quite quite in vogue. That means buyer beware. आप कुछ खरीदने जा रहे हैं, whether you are going to a Sarojini market and you're purchasing something, so it's your moral responsibility being a consumer, being a buyer, that you will purchase that product with due diligence. So now the concept has completely changed in a Consumer Protection Act 2019. Now it's a seller beware. So the objective is completely changed in Consumer Protection Act. Now you will definitely think, ma'am, why you are discussing about competition law and why you are discussing Consumer Protection Act and why there's two separate legislation in India to protect the interest of consumers. The basic objective behind these two laws are same. That is the protection and a consumer welfare, right? Now, why there is segregation of these two laws? देखिए, आपको एज अ लेमैन अगर इस टॉपिक पे मैं बताऊं तो आप इमेजिन कीजिए आप कंज्यूमर कब बनते हैं? जब आप उस चीज को कंज्यूम करते हैं, राइट? बीइंग अ बायर आप मार्केट में जाके किसी प्रोडक्ट को परचेज करते हैं, बट प्रायर टू दैट परचेज करते हैं और उसमें कुछ कमी निकल आती है या उस प्रोडक्ट में पर्टिकुलरली देयर इज सम डेफिशिएंसी, then you can go to Consumer Protection Act 2019. But prior to purchasing that particular product, there are certain practices which are unfair trade practices which are committed in the market. आपने मार्केट में देखा ना, buy one get one free, buy one get three free. आपने ये भी देखा है, if you want to purchase one thing, you have to purchase the complete range. बॉडी शॉप पे आप जाते हैं, देखते हैं आपको चाहिए सिर्फ hand lotion, but you have to purchase a complete range because it is coming in a basket form. What it is basically against the consumer welfare. Why consumer will give the extra amount on that particular basket for other products? ये चीजें क्या हैं? आप देखते हैं मार्केट में there are practices, these are known as a tie-in arrangement, और ये सारी चीजें competition law में देखी जाती हैं. So prior to becoming a consumer, if something is happened with that particular product, is basically governed by the Competition Act 2002. Okay? So this is a basic difference. And why there are two laws? The basic reason is we are not done with our competition policy. There are very rare countries in the world where these two legislation are combined in a one legislation. Australia is one of the example. There is a One Consumer Act, right? They have the Competition and Consumer Law 2009, so sorry. Yeah. So because they have worked quite hard on the foundation of policy making. Now, 24 December of every year is observed as a National Consumer Day, as Consumer Protection Act of 1986 was enacted on this date, right? So the date on which this particular law came into force is a National Consumer Day. Now I'm just completely concentrating on Consumer Protection Act. I'm not dealing with this Competition Act 2002, right? So there are these three major Consumer Protection Act 1986, Consumer Protection Act 2019, and very, very important Consumer Protection E-commerce Rule to 2020. Now you will say, ma'am, why it is different? Why? It's a very major change in a consumer protection law. You know this thing, at the time of 1986, consumer was a person who's just basically consuming a thing. But now, consumer is not this consumer. Consumer is a consumer who is basically availing the facility of online transaction. It's not a consumer who is personally going for a purchasing. He is purchasing on a laptop. So for those kind of consumer, we just need a different kind of legislation. And these particular consumer protection rules are supporting the basic major substantive law, which is the Consumer Protection Act 2019, right? Now the Consumer Protection 1986, because I'm just discussing these three laws now. Consumer protection, a milestone for consumer rights protection laws. It regulated the law and rules relating to the unfair trade practices, related to violation of the rights of the customer, but it did not hold any activity provision for protecting the rights of consumer in case of online transaction. देखिए 2019 तक हम लोगों के पास कोई there was a completely dearth of law. We were not having an adequate mechanism to handle the problems which are arising through an online transaction, right? Now, Consumer Protection Act 2019, it is addressed issue not dealt in the 1986 laws. The Consumer Protection Act 2019 gave suo motu power to the regulator, along with expanding the scope of framework of the law of 1986. Very, very nice and very different kind of provisions are incorporated in Consumer Protection Act 2019. As prior to this presentation, Gunjan Gupta ma'am was discussing about section 138. So there is section 139, 140, 141. So there are certain major changes with regard to jurisdiction in bouncing of check. In a same way, there are certain major changes which are basically somewhere helping and somewhere welfaring the consumers. Now these are the Consumer Protection E-commerce Rule 2020. The Consumer Protection Rule for E-commerce 2020 provides a framework to control the marketing, sale, and purchase and trading of goods and services online, dealt with some important problems like information disclosure, grievances, redressal system, etc. Now let's talk about Consumer Protection Act. This is a brief introduction which I've given. The Consumer Protection Law 1986 was found lacking in several aspects and in achieving the desired objective of protection of the interest of consumer. For instance, Consumer Commission entrusted with the settlement of consumer disputes under the erstwhile laws suffered from high volume of mending of cases, because there was no as such law with regard to online transactions, or certain local laws were somewhere supporting, IPC was somewhere supporting, and there are certain different laws such as adulteration law, such as drug control act, such as prevention of food adulteration, agriculture product grading and market act. So these were the supporting legislation which were basically handling the issue at that point of time. Now we have a separate legislation for online thing, and this particular act came into force in 20th July 2020. The act provides the establishment of CCPA. This is a very important change. CCPA is a Central Consumer Protection Authority. It's working as a regulator of consumer affairs, basically. It promotes and protect and enforce the rights of consumer as a class. And apart from this, this act also provide for simplifying the adjudication process, which is very much required, because the consumer is the person in India who is not even educated. So we just need a law which is for layman actually, and we need a procedure which is quite effective for a layman. So the basic provision related to mediation as a ADR, which is an alternative dispute resolution mechanism. So this is a time आपको I think mediation का knowledge होगा. This is a one adjudication process, which is a normal process, and there's one ADR, which is an alternate dispute resolution mechanism, which is basically a mediation in this act specifically. Mediation में आपके कुछ grievances होते हैं being a consumer. So उन grievances को एक mediation cell establish किया गया है under CCPA, under Central Consumer Protection Authority, and आप judicial way से grievances को handle नहीं कर रहे हैं. You are basically handling the grievances mechanism through a mediation, which is quite easy and less time consuming. So how does Consumer Protection Act function? Because the Consumer Protection Act, there's a 3-tier quasi-judicial machinery, which is called a Consumer Commission, has been established as a district consumer commission, district consumer redressal commission, basically, state and national level, to provide a simple, inexpensive and speedy redressal to a consumer dispute. A consumer can make a complaint against a company, manufacturer, trader for a defective product, deficiency of services, or other unfair trade practices. CCPA provides under this act aim to protect the rights of the consumer by cracking down the unfair trade practices and false and misleading advertisements that are detrimental to the interest of the public and consumers. To support this particular legislation, there are like law में हमारे आजकल we just talk about a modern kind of law. So I used to teach company law as well. So company law came into force in 2013. So there is basic substantive law which has been written in the Companies Act 2013. But there are certain rules and regulations which are keep on changing. और वो अगर change होता है, आपको पता है amendment procedure is quite tough. To amend a single line in an act is a tedious task. So the substance will remain same in a Consumer Protection Act, but the rules and regulation which are associated with as a procedure of that act can change on a timely basis by the ministry itself. So here the Department of Consumer Affairs is empowered to make a rules and regulation with regard to Consumer Protection Act. So these are the rules, basically, general rules, Central Consumer Protection Council rules, Consumer Dispute Redressal Commission rule, mediation rule, e-commerce rule. E-commerce rule came into force in 2020. And now there is a major amendment in 2021. That too in July it was proposed. So you can understand, we don't require amendment procedure to make a change in a rules. By ministry itself, by the help of stakeholders, ministry can anytime change the rules and regulation. Because देखिए e-commerce rule कब आए? आपके COVID-19 के time में आए. एंड बहुत बेनिफिशियल रहे बिकॉज कोविड के टाइम में कंज्यूमर्स, एवरी कंज्यूमर वाज अ ई कंज्यूमर, right? So for a time being, we enacted e-commerce rule in 2020. So तब की चीजें मैनेज हो गई, बट देवर जब आप ऑपरेट करते हैं कुछ रूल्स को, एट दैट पॉइंट ऑफ टाइम यू विल फील दैट देयर आर सर्टेन काइंड ऑफ lacunas, procedural lacunas in these rules. These rules are not consumer friendly. So, so the major amendments are basically proposed in an e-commerce rule. And in July, the floor was open for stakeholder to make certain suggestions. Right? What is the difference between consumer protection before and after? So here in a Consumer Protection Act, we have a regulator, which is a CCPA. In 1986, it was not there. We have a separate consumer court. Complaint can be filed in a consumer court where the complaint reside or works. Here, the product liability is a very new concept. We are using a product, right? So we are using a product, we are availing a services. So the person who is a manufacturer of of that product is responsible, and the person who is providing that product is responsible. We will separately deal with this issue of product liability. So this is a new inclusion by Consumer Protection Act. Pecuniary jurisdiction was enhanced. Earlier it was 20 lakh, and now it's like for a district it's a 1 cr, and for a state commission it is 1 cr to 10 cr, and for national above 10 cr issues were taken care. E-commerce, again a new e-commerce rule incorporated in a Consumer Protection Act, and a mediation cell, it's a new inclusion again. This was a thing of Consumer Protection Act 1986 and 2009. Very important line here. The ramification of CPA 2019 cannot be precisely gauged as many new concepts have been introduced. However, what can definitely be said is that everyone involved in a transaction, other than a consumer, will have to be more careful and cautious than ever before. That means now the consumer is not aware, now the seller is aware. So there is a clear shift in the principle from caveat emptor to caveat venditor. So seller beware. So these are the silent features I'll discuss. These are the basically some of the slides are basically discussing about. By the way, this Department of Consumer Affairs is having a separate huge fund for awareness of consumer rights, for awareness of this new Consumer Protection Act. So these are the few. I'll definitely share these slides with you. Now, these are the basic topics which I have.
Sorry to interrupt, Dr. Aarti. I think that slides, if presented in the full mode, then it will be more beneficial, as you also work hard for that. So please, what our technical team from the ILLL, yeah, it is okay. But if you want that someone from IL present, and you can say next, so that they can play if you want.
So I have shared a slide with you.
Okay, okay. So should I play or ILLL? Okay, they shared.
You can
Yeah, share. It is shared. Now you can see. Please, next slide.
Thank you so much.
Ravi, next slide.
Yes.
Mr. Ravi, play next slide.
JP, it will be a very difficult task because I have made almost 95 slides. Can you imagine? I have to scroll down very fast.
Okay.
So that's a problem. I think I have to operate this.
Okay, it's up to you.
Because it's not moving now.
Ravi, are you there? Yeah, they move. Start.
Yeah, just ask him to make it,
full screen.
Full screen mode. Yes.
Ravi, please do it in full screen.
Ravi, make it full screen.
Aarti, he will also have some problem. You can share with yourself.
Okay. Okay. Uh, I think this is the very first time I am just share. I faced this kind of problem. Okay, let me try. No, it's fine. So these are the slides. It's visible.
No.
Okay. Now it's visible. It's
Yeah,
visible.
ma'am. Yeah, it's visible now.
Okay. So these are the basic things which are from Consumer Protection Act. That this new act, Consumer Protection Act, replaced the Consumer Protection Act 1986, and new act is covering these all new features, which are Consumer Protection Councils, Consumer Dispute Redressal Commission, mediation, product liability, e-commerce and direct selling, and penalty for adulteration of spurious goods. There's establishment of separate regulatory body, as in Competition Act. There's a CCI, which is a Competition Commission of India, as a regulatory body. Here, the regulatory body is a Central Consumer Protection Authority. This is very first time in the history of Consumer Protection Act in India, and the basic aim was to promote, protect, and enforce the rights of consumers. Now, the new feature, which is a product liability, I'll be discussing this separately. And the new e-commerce platforms rules, this also I'll be sharing with you separately. You can see that product liability provision. To understand product liability provision, which is to deter the manufacturer and a service provider. आपको पता है, basically there are two kinds of person in a commercial law, whether it is a company law, whether it is a sales of goods, whether it is any law which is in a commercial nature. There are two kinds of category. One is a person who is providing a product, who is known as a manufacturer, and second is a person who is providing a services, which is known as a service provider. So these two person, for delivering defective product or deficient services, if they are delivering, I'm saying this now, it's not a time for buyer beware, it's a time to seller beware. You will be responsible for the fault in a product. Buyer will not be responsible. So you have to be very cautious when you are entering into a market, right? So I am covering basically these 9 major points. These are very useful points, and in a day-to-day life also, you are encountering almost everything, right? So these are the new 9 changes which are brought into a Consumer Protection Act 2019. So the first, I'm taking care of product liability under CPA 2000. What is product liability? Why does it apply to? Who does it apply to? A product liability means an action can be filed against a product manufacturer. Listen carefully. You can file a case against a product manufacturer, against a product service provider, or a product seller, as the case may be. I am saying product seller. What do you understand about product seller? On an online mode, you are purchasing something from Amazon. अब Amazon में जो प्रोडक्ट आया है, so the product manufacturer has done its work, compliances work perfectly with regard to quality assurance of that product. And a buyer is also ensuring by accepting certain uh, you know uh, promises. There are certain agreement. There are, I think आपको contract में पढ़ाया होगा कि that you have online, आप जब नया फोन परचेस करते हैं बहुत सारे agreements होते हैं ना, टिक 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 करके आप yes yes I agree कर देते हैं. In a same way seller is also agreeing for certain things. Now it's a online provider, which is Amazon. It's an online platform which is also coming in a radar of product liability. There are many cases in which आपने सुना होगा कि Amazon से कुछ परचेस किया एंड बीच में ही Amazon के कुछ पर्सन्स होते हैं जो प्रोडक्ट्स के साथ कुछ हैंडल करते हैं, कुछ डिफरेंट थिंग्स हो जाती हैं प्रोडक्ट्स के साथ. सो एट दैट पॉइंट ऑफ टाइम प्रोडक्ट सेलर इज आल्सो रिस्पांसिबल अंडर प्रोडक्ट लायबिलिटी. CPI 2019 define each of these expression in a very wide term to bring within their fold every possible aspects of a product liability claim. Condition that attract liability, product liability. A product manufacturer, firstly I'm discussing with regard to product manufacturer. A product manufacturer shall be liable if the product contain a manufacturing defect, if the product is defective in design, if there is a deviation from manufacturing specification, or the product does not conform to the express warranty, or the product failed to contain adequate instruction of correct usage to prevent harm or any warning regarding improper or incorrect use. Liability of product service provider. A product service provider shall be liable if the services provided by him was faulty in quality, nature, and manner of performance, if there was an act of omission or commission of negligence or conscious withholding of any information which causes harm, or the service provider did not issue adequate instruction or warning to prevent any harm, or the service did not confirm the express warranty or a term or condition of the contract. There are certain exceptions to product liability, like in which this particular liability can't be imposed on a product provider, product manufacturer, or service provider. So these are the things that the product ought to have to use only by under a supervision of expert. If thing is written this and you have used that particular project, if something happened, so this product liability can't be imposed on a product manufacturer. Any product liability action based on a failure to provide adequate warning or instruction, the product manufacturer will not be liable. The product was purchased. There are certain things, even prior to CPA 2019, in most product liability action, one or more of the above defenses were taken. These defenses now have a statutory recognition. Earlier, through a precedent, we used to ratify the case, but now through a statutory recognition, we are basically accepting these exceptions. Now, concluding analysis of product liability. Basically, product manufacturer, seller, or service provider will need to ensure that they have done their due diligence properly to be compliant with the various requirement under a different legislation. A checklist of such compliances backed with proper legal and technical advice would go a long way in protecting their interest and the interest of the consumers. The introduction of product liability regime is a welcome change and will streamline product liability actions. There is a clear shift in a principle of buyer beware to seller beware. Even though some aspects are unclear, the new regime is set to change the legal landscape of India pertaining to product liability. Now, the second thing is the unfair contracts. So there are many unfair contracts in which you basically agree, like through an online mode also, there are certain sites where you agree without even understanding what has written there, you agree to that contract. That also amount to a contract, by the way. So 2019 Act has also introduced the concept of unfair contract. Because of online mode specifically, and there are certain multinational companies which are coming in India, so they are also changing the fashion of business in India. So because of those reasons, because 1986 was a quite old law, and after 1986, there was a period of liberalization, privatization, and globalization where we relaxed our FDI, foreign direct investment policies. That was the time of 1991. And after that, there is a big changes in these 20 years. And we waited a lot for changing in a Consumer Act. So that's why there was a dire need to, define the unfair contracts. So any contract between a consumer and a manufacturer or service provider or a trader whose term bring about a significant change in the consumer rights under the Act. These terms are requirement of excessive security deposit by the consumer for the facilitating the performance of an obligation under the contract. यहाँ पे आपके banks भी आते हैं. Imposing penalty for breach of contract on the consumer which is not in a proportion with the loss suffered due to such breach, not accepting early debt payment along with the applicable penalty. I think you are getting my point. Allowing one of the party to terminate the contract without any reasonable cause or unilaterally. Entitling one party to assign the contract to the detriment to the consumer and without his consent. Imposing unreasonable condition, obligation, or a charge on the consumers that put him in a disadvantageous position. These are termed as a unfair contract. In the previous legislation, complaint could be filed only if the unfair trade practice or a restrictive trade practice was adopted by any trader. There was no point with regard to unfair contract. Now, unfair contract has also been added, which further broaden the ground to file a complaint and allow the consumer to challenge contract which are unfair, unilateral, and unreasonable. And the above provision would directly impact the financial institutions such as a bank, as the apex court has already stated that a bank also get covered under this act. This would specifically take into account contract entered with banks e-commerce platform where parties are not left with any option but to agree to the standard term to avail that services. So with such a broad subjective definition, it remains to be seen how court would interpret in a case of online contract. देखिए ये एक्सपेंशन ऑफ अनफेयर ट्रेड प्रैक्टिसेस हैं जिसको आप डे टू डे लाइफ में यूज करते हैं. 3 type of additional unfair trade practices have now been added to the list, which are as follow: failure or non-issuance of a bill or a cash memo. आप कहीं जाते हैं वहाँ कैश मेमो आप जनरेट नहीं होता है, that will also come into a unfair trade practice. Refusal to take back or withdrawal defective goods or deficient services, or refusal to refund the consideration amount paid within the period as stipulated in the bill. That will also come in the category of unfair trade contract. Disclosure of consumer personal information to any other person unless such disclosure is made in accordance with the provision of any law for a time being enforced in a public interest. काफ़ी सारे डेटा प्रोटेक्शन लॉज अभी हैं जो आपके इतने सारे डेटा बहुत सारी साइट्स पे जाके आप यस अग्री करते हैं. सो बहुत सारी आपकी पर्सनल इंफॉर्मेशंस आउटसाइड इंडिया बहुत सारी जगहों पे चली जाती है. टू प्रिवेंट दोज मिसयूज ऑफ डेटा, this is also covering in this particular unfair trade practice under this particular act. This is example: Connaught Place Restaurant Limited versus Kapil Mitra. The complainant filed a complaint against the scheme McDonald में खाओ हर बार प्राइस ले जाओ, because he was not allowed to avail the benefit of the scheme without a subsequent spending another sum of 20 rupees. Moreover, the winner were not revealed to the participating customer. So National Consumer Dispute Redressal Commission में ये case गया, and it was held that a scheme entitled unfair trade practice and awarded compensation of 30,000 and the cost 70,000 respectively. Now the fourth point is a misleading advertisement. Misleading and false advertisement were all, though it was there in 1986, now it has come in a very different way, because now even the person who is basically a part of misleading advertisement, that person can be held liable under this act. There's a very different, I think Amitabh Bachchan and Preeti Zinta, these are the people who have already come into a picture in this particular provision, because they were basically endorsing certain products which were basically not appropriate with standards. So misleading and false advertisement is one of the many aspects that were introduced in 2019 Act. The repealed act did not deal with the concept of misleading and false advertisement. So these are the basic sections which talks about the definition of misleading advertisement. So these sections I have, uh, added here. Misleading advertisement during COVID-19. So there was a eat chicken beat corona. The advertisement in question was taken out by a Karnataka Poultry Farmer and Breeders Association and Vancouver. The advertisement claimed that eating chicken boost immunity. Acting on a complaint filed by a People for Ethical Treatment of Animal, ASCI, instructed that the online ad be taken down. Ayush Ayurvedic treatment cures COVID-19. There was a news flash with regard to Ayush Ayurveda product treating COVID-19. The Ministry of Ayush wrote to all states and the Advertising Standard Council of India to take action against misleading ads and promotion about the Ayurvedic treatment to prevent and cure COVID-19. So these are some of the deceptive advertisement. More than 80% of dentists recommend Colgate. These are the deceptive and misleading advertisements. This is a new latest case, Horlicks Limited versus Zydus Wellness Product Limited 2020. In this case, the Delhi High Court issued an interim order wherein Zydus owned was restrained from advertising. Complan had aired an advertisement where it compared the brand with Horlicks and declared that 1 cup of Complan was equivalent to 2 cups of Horlicks. The reasoning behind the order was that advertisement was misleading. The Delhi High Court highlighted the category of channel that was used to disseminate the advertisement in this case. Any advertisement aired through a electronic form of media would lead to create well fortified repercussions on the customer than if it was given out on a print media. So such kind of things are taken care by the new act. Now, if you want to file a complaint in a Department of Consumer Affairs, so there's a specifically provision where you can register your complaint, grievance against misleading advertisement. There are certain penalties also. Penalties are basically CCPA can impose a penalty up to Indian rupees 1 million and up to 5 million for every subsequent violation. Even though this particular thing, however, the endorser would be exempted from any liability if she established that they undertook due diligence to verify the veracity of the claim before endorsing the same. So this is another provision in which the endorser can evade from liability. Now, another fifth point, which is a consumer dispute redressal form. I think to understand this particular thing, there's a Consumer Dispute Redressal Commission. This is the very first time as a regulator, CCPA has established a 3-tier mechanism to redress the dispute. So this is a Consumer Dispute Redressal Commission. Consumer can file a complaint with CDRC regarding any of the following: in case of defective goods, services, overcharging of deceptive charges on the goods and services, any unfair restrictive trade practices, offering services or sale of goods which can be hazardous to life or not safe. Complaint can filed in a district level, state level, and all these complaints can be made online electronically. This is a jurisdiction. If a complaint is related to rupees 1 CR, so district CDRC is there. It comes in a pecuniary jurisdiction basically. If your complaint is having a claim of more than 1 CR but less than 10 CR, so you will file a complaint before a state CDRC. CDRC is a Consumer Dispute Redressal Commission, and National CDRC more than 10 crore rupees claim. What is the appealant process? This is the appealant process. Firstly, you will file a complaint in a district forum, then in a state commission, then a national commission. And then after appeal will lie with Supreme Court. Apart from this, at any point, if you want to go for a mediation, which is an alternative dispute resolution mechanism, you can avail the facility of mediation, which is already available in a Consumer Protection Act 2019. It has simplified the dispute resolution process because it is for layman basically, right? Now, next is the consumer rights. Very important slide. Being a consumer, you should know your rights. So there are 6 rights which are enumerated in a Consumer Protection Act 2019. Right to be protected against the marketing of goods, products, or services which are hazardous to life and property. The right to be informed about the quantity, quality, potency, purity, standard, and the price of the goods, product, and services, as the case may be, so as to protect the consumer against unfair trade practices. Right to be assured, whenever possible, access to a variety of goods, products, services at a competitive price. The right to be heard and to be assured that a consumer interest will receive due consideration at appropriate fora. Fifth right is right to seek redressal against the unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumers. And last is the right to a consumer awareness, on which the Department of Consumer Affairs is spending hell lot of money. You will see these are consumer rights. Now the rights are this, that on a medicine, it's a mandatory thing in India that medicine should not be used after the expiry date because it can lose its effectiveness, and unsafe batch number is compulsory. In case of a recall, the batch number will be quoted, and there will be mandatory to associate a barcode on a medicine. A Government of India enacted the Right to Information (RTI) Act 2005 to ensure citizen access to public information. Right to Information Act is a comprehensive set of rules and guidelines that ensure and provide all information to the respective citizen about the functioning of government department. This is I think, nitty-gritties and legalities with respect to constitution, with respect to functioning of CCPA, Central Consumer Protection Authority. These are the important functions. These are the structure and composition. This is the procedure. And this is basically Central Consumer Protection Authority is working as a regulator. It protects the enforce the right of consumer as a class. It is having an investigation power which can be delegated to DG investigation, and power to recall goods as well. It has a power to issue direction and penalties for false and misleading advertisement. It has a separate power of search and seizure. These are under the Jago Grahak Jago. These are the pamphlets which are basically a 6th right of awareness. For this purpose, the department itself is basically giving an advocacy for consumer laws. Next is a mediation, 8th point. Mediation is basically an alternative dispute resolution mechanism. It refers to mediation by consumer commission wherever scope for early settlement exists and a party agrees for it. आप जुडिशियल तरीके से डिस्ट्रिक्ट फोरम में या स्टेट कमीशन या नेशनल कमीशन में एक प्रोसेस से जाएंगे, इट विल टेक सम टाइम. सो अगर आप वहां से नहीं जाकर एक अल्टरनेटिव डिस्प्यूट रेजोल्यूशन मैकेनिज्म के थ्रू you want to handle your grievances and you need a speedy judgment and you want to settle, rather to say it's a settlement kind of thing. So the mediation cells are already attached with the Consumer Commission because of this Consumer Protection Act 2019. Right? Mediation means process by which a mediator mediates the consumer dispute. It's a consumer dispute settlement mechanism. So the mediation rules and regulations are this. There are certain matters which can't be referred to mediation, which will definitely go through a proper judicial channel. So those matters are matters which are related to medical negligence, resulting into grievous hurt, grievous injury and death, default or offense for which application for compounding of offense have been made by one or more parties. I was listening one day, I think some of you were talking about compounding of offenses. तो ये जो legal terminology है ये interwoven है, हर subject में applicable होती है, right? So now the next point, which is again a last point, a very important point, which is the adulteration of product. Adulteration means any material, including extraneous matter, which is employed or used for making a product unsafe. Section 19 stipulate for the punishment of manufacturing, of sale, or storing, selling, or distributing, or importing product which are containing adulterant. So ये है, in case it doesn't result adulterated substance you have used, product you have used, but it doesn't cause an injury. So in that situation, imprisonment up to 6 months and fine up to 1 lakh rupees. If injury not amounting to grievous hurt, then imprisonment till 1 year and fine is up to 3 lakh rupees. If there is a death of consumer, which is a cognizable and non-bailable offense, so the manufacturer or service provider can be go behind the bar up to 7 years to life imprisonment, and fine is up to 10 lakh rupees. There's one honey fraud under this adulterated thing. So with the onset of COVID-19 pandemic, honey sales were up by 35% due to a beneficial property of honey that could help people build immunity. The Center for Science and Environment investigated the same, showcasing the many big brands like a Dabur failed the adulteration test as sugar syrup was being used in place of honey. This adulteration could only be identified using advanced tests like a nuclear magnetic resonance. So, based on a CSC finding, the Department of Consumer Affairs asked the Central Consumer Protection Authority to investigate the matter as it regulates false or misleading advertisement. So, there is now to understand that consumer laws may consumer department, so Department of Consumer Affairs is associated with so many branches, and one of the branch is a Food Safety Standard Authority of India. Abhi, I'll just clarify this thing. There are certain other way and means to consumer protection. You can go for lok adalat, you can go for public interest litigation, awareness program in which legal aid has provided for consumer protection. There are certain consumer organizations who are working for the protection of consumer welfare, and there's a redressal forum and consumer protection councils. Now, let's start with the practical thing. So this is a site where you will see the consumer affairs, how Department of Consumer Affairs is working out. Look, there is National Test House, NTH, for testing purposes. There are certain electronic equipment which are tested, which are basically for the testing of those equipment. This NTH is working. Bureau of Indian Standards, such as the ISI mark, Agro mark, these are basically established. These are the standards which are established by a Bureau of Indian Standards. There's a National Consumer Helpline, Jago Grahak Jabo. So these are the basic, other routes of consumer protection department. So it's a one of the department, Bureau of Indian Standard. So there's a one wing of Department of Consumer Affairs. This particular wing is established on 12th October 2017. They basically harmonize the development of activity of standardization, conformity assessment, and quality assurance of goods, article, processes, system, and services, and the matter connected therewith or incidental to. 32 branches all across the India. In 2020 till 2021, so there are total standard which are formulated by BIS is basically 613 in 2021. New standard they have evolved is 343 and revised certain old standard that are 270, such as a egg mark. This is a standardization of commodities, hallmark in gold commodity, in gold basically, and ISI mark for appliances for quality and safety products. Next is a metrology packaged commodity rules. So there's a separate body which are covering in our Consumer Protection Act itself. Consumer protection has always been one of the main thrust area of a public policy formulation. Use of proper, accurate, standard, weight, and measure is a very important or effective functioning of economy, as it plays an important role in promoting welfare of a consumer. Because in India, consumer laws are basically for one objective, which is a consumer welfare. So this particular act is directly helping to for achieving the objective of consumer welfare. So these are the silent feature. Legal metrology packed commodity rules. Now there are certain strict rules which are made like this, that name and address of the manufacturer, packer, and importer should be there. Net quantity you have to mention on that product. Resale price maintenance, consumer care details, month and year of manufacturing, packaging, and importing. Country of origin and imported product. There's a very important thing which are included now. So this is a thing, right? This is a details to be checked on every pre-packaged commodity. Right? Now next is a reform for essential commodities. आवश्यक वस्तुओं के लिए सुधार. So they are basic essential commodities such as a pulses, such as a jute, oil, medicines. So government is taking various initiative and in administration of Essential Commodity Act. And for this, basically, government is working under this particular branch of Department of Consumer Affairs. There's another thing, reform in a price monitoring division. So price monitoring is very much required because there are certain times जब आपके अचानक से onion के price high हो जाते हैं. So you can't speculate like this. So just to stop and just to control such kind of speculation, government has now strengthened the price monitoring cell and price stabilization wing. That wing is a price monitoring division. These are the list of commodity which are monitored closely. These all are for a consumer welfare and consumer protection. And there's a national test house for the settlement of disputed. NNTH is providing services to consumer broadly classified testing and quality evaluation of material and a finished product, calibration of testing machine, measuring instrument, etc. So basically, this particular national test house is working into a 6 discipline, which are related to chemical, civil, mechanical, electrical, non-destructive, and rubber, plastic, paper, and textile. This is a testing agency, basically, National Test House. How to register consumer grievances. For this also, there's a step-by-step guide. And it's an online grievance mechanism altogether. If you want to know about the product or about the functioning of Department of Consumer Affairs, you can access the information through RTI. So this facility is also there. This portion I wanted to cover, but again, there's a time constraint. I have made a presentation on consumer rights in a digital era. I just need your assent for that, or we should stop our presentation here. Over to you, JP.
Thank you, ma'am, for your presentation. However, it was bulky, but I know that all these things are very important and everyone we want to cover it. But yes, we have some time constraint. And I also started to receive the calls from the participants also that they have some other assignments, appointment also. Anyway, so this is a very wonderful session and very enriching experience of the participants. So I am thankful to you on the behalf of all the participants. And I'm sure this way of the teaching is good. So participants, we may share with the slides so you can check these also. Okay, so thank you, Aarti, for this giving your precious time. And
JP.
yes.
one thing I just want to add, JP, for the participant, we are basically law teachers, and we are not supposed to perform in this way. This is our slides which I specifically prepared for this presentation only, because we used to discuss, as a law teachers, we used to discuss the sections and legislation, and here I have just tried to incorporate certain practical things just to make them understand, just to make this particular consumer protection interesting. Yeah.
Okay. Yes, it is too. It's very difficult task for the law teacher when he go in the class without the law background. Part students are there, but yes, we are still trying, and we are happy to say that with the experience of the last 3 or 4 days, including today, the participants' response are very encouraging, and the participants are getting more and more. If anyone have any kind of the question who want to ask with Dr. Arthil, please feel free to ask. Anyone? I think by your detailed presentation, everything is covered. There is no question. Yes, Preeti.
There can be two implications for this presentation, by the way,
Hello,
JP. Yeah, Preeti.
am I audible?
Yeah, yeah, you audible.
Ma'am, thank you very much for such an informative and wonderful presentation. And we actually, learned so many new things about consumer protections. I mean, our rights as a consumer. Thank you.
Thank you so much, Preeti. So thank you, JP, and thank you all the participant, and all the best for the last day. I think tomorrow is the last day of presentation, or right, the
Yes.
sessions.
Okay. Thank you, ma'am.
Yeah, that's nice. Thank you so much.
Okay. So now I'm sharing the link, attendance link in chat box. So please complete it before 6. However, we are a little bit late today, but still, let me check. Okay, so see you tomorrow, and we will. The video of the today is also available on the IEEE YouTube channel. So okay, thank you. Bye. See you tomorrow. Okay, there is a, oh sorry, there is a one announcement is there. There is a one session on copyright and patent. Now that session will be taken by the Dr. Chitis Singh in place of the Professor Alka Chawla. So this is a little bit change in the schedule. So please note it. Okay, thank you so much for all the participants.